those who live and work in any federal area. Now, the federal government knows that it cannot tax state citizens who live and work outside the territorial jurisdiction of Article 1, Section 8, Clause 17, or Article 4, Section 3, Clause 2 of the U.S. Constitution.
Now, 1 second, please. Anybody object to eating outside on the creek?
Yes.
Yeah, that'd be great.
It's 100 degrees out there, dude.
That'd be cool. Be nice.
Okay. Where do I leave off at now?
Now the government knows.
Now, the government knows that it cannot tax a state citizen who live and work outside the territorial jurisdiction of Article 1, Section 8, Clause 17, or Article 4, Section 3, Clause 2 in the U.S. Constitution. So in 1940, Congress passed the Buck Act at 4 U.S.C. 105 through 113. In 110E, the Act authorized any department of the federal government to create a federal area or imposition of the Public Salary Tax Act of 1939. This tax is imposed at 4 U.S.C.S. 111. The rest of the taxing law is found in the Internal Revenue Code. The Social Security Board had already created a federal area overlay. The term state at 4 U.S.C. 110D includes any territory or possession of the United States. And at 110E, the term federal area means any lands or premises held or acquired for the use of the United States or any department established or agency of the United States in any federal area or any part thereof which is located within the exterior boundaries of any state shall be deemed to be a federal area located within such state. There is no reasonable doubt that the federal state is imposing an excise tax under the provisions of 4 U.S.C. 105, which states in pertinent part, state and so forth taxation affecting federal areas, sales or use tax. No person shall be relieved from liability for payment of collection of or accounting for any sales or use tax levied by the state or by any duly constituted taxing authority therein having jurisdiction to levy such tax on the ground that the sale or use with respect to which such tax is levied occurred in whole or in part within a federal area. And such state or taxing authority shall have full jurisdiction and power to levy and collect any such tax in any federal area within such state to the same extent and with the same effect as though such area was not a federal area. Irrespective of what the tax is called, its purpose is to produce revenue. It is an income tax or a receipts tax under the Buck Act. Thus, the obvious question arises, what is a federal area? A federal area is any area designated by any agency, department, or establishment of the federal government. This includes the Social Security areas, designated by the Social Security Administration, any public housing area that is federal funding, a home that is federal bank loan, a road that is federal funding, and almost everything the federal government touches through any type of aid. Springfield versus Kenny. This federal area attaches to anyone who has Social Security number or any personal contract with the federal government, state governments. Through this mechanism, the federal government usurped the sovereignty of the people as well as the sovereignty of the several states by creating federal areas within the boundaries of the states under the purported authority of the Article 4, Section 3, Clause 2 of the Federal Constitution, which states, Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory of other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. Therefore, all U.S. citizens, i.e. citizens of the District of Columbia, residing in one of the states of the Union are classified as property or franchises of the federal government and as an individual entity. Under the Buck Act, the federal government has created federal areas within the boundaries of all the several states. These areas are similar to any territory that the federal government acquires through purchase, conquest, or treaty, thereby imposing federal territorial law upon all people in these federal areas. Federal territorial law is evidenced by the executive branch's yellow fringe U.S. flag flying in schools, offices, and courtrooms. You must live on land in one of the states in the Union or of states, not in any federal state or federal area, nor can you be involved in any activity that would make you subject to federal laws. You cannot have a valid Social Security number, a resident driver's license, or a motor vehicle registration in your name. You cannot have a federal bank account, a federal register account number relating to any individual persons, Executive Order number 9397 of November 1943, or any other known contract implied or in fact that would place you within any federal area, and thus within the territorial jurisdiction of the municipal laws of Congress. Remember, all acts of Congress are territorial in nature and only apply within the territorial jurisdiction of Congress. Now, all these cases I've cited here, I want you to go back and pull them down. There's over 100 cases in this book that supports everything I say. Nothing is my belief system. This is all the law. So go to findlaw.com is a good one. It's free service. Go there, findlaw.com. And type in these numbers I give you. Put 338 U.S. 217. It pulls down the whole case for you. Those are Supreme Court cases or appeals cases, and just save them. Yes.
The Social Security number, the driver's license that I have in my possession aren't me. Is that reasonable?
Yeah, but you've got them. You've got them, and the judges will say, "Do you have a Social Security number?" I've
I
heard
don't have a
defense.
Social Security number. The created fiction has it.
I know, but you
I can't argue that.
no. The fact is, they'll say if you have one in your possession, you have it's yours. And that ties you directly to taxation. Again, all these things you have, the contracts you have, are contracts you don't need. They're adhesion contracts. You signed them. It's a dumb mistake, big dumb mistake, but you made it. You have an obligation now to clean it up. So with a nunc-pro-tunc affidavit, you clean all your mistakes up. Get rid of them all. And then once you have those things gone, there's no problem any longer. So that's what you got to do. Get rid of
How do you deal with automobile registration?
Number one, the registration is their property because when you buy a new car, the manufacturer's certificate of origin is sent to the state. That's the real ownership document. That's state vehicle, and because it's their vehicle, they require you. It's because certificate of title means there's a title someplace. You don't have it.
Right.
They'd have it. So, like if you buy a new car, you want to tell the guy you buy it from, I want the MSO, not the government. That's mine. And don't get one. Once it's there, it's registered. You've got to do it. It's their vehicle. Yes.
Okay, so in realizing that we've made these mistakes in the past, and so we go to rectify them by writing the letter saying, sorry, I made this mistake. I'd like to rectify this, please. Take my name off this contract, for the driver's license, social security number, marriage license, business license, all these things that you do. Are we going to discuss later on in the week here strategies about, because essentially the colloquial businesses that we have to deal with, banks especially, are making it almost impossible to basically live and do business without the use of these statutory numbers and statutory IDs and things like that. Are we going to discuss about strategies on how to deal with that, or how to bring...
I'll give you a strategy right now. Some people, I won't say who, but some people, for years used President Nixon's Social Security number because he was dead. He didn't need it anymore. There's all kinds of ways to do it.
Isn't that fraud, though?
Yeah, I was going to say, wouldn't that be considered fraud if you were...
They want a number. Give them a number. Give them a number. I just say, give them maybe one digit off or something like that. Where 9 could be a 7. It depends who's writing it. But, so you say, I didn't tell you that number. You put it down. My number's 7. You put a 9 down. That's your problem. Those are mistakes.
What was that?
I have used that strategy successfully.
But like a lot of people, like in Florida, you require you to have your fingerprint, any bank transaction. Well, I didn't like that at all. So I give my knuckle instead. I give a knuckle print. They never challenged it. I just give my knuckle and go roll my knuckle.
I just smeared it.
Just roll. Give them a knuckle. Give them a knuckle. They don't. The girls don't know. But I used to write on all my bank cards. I would write without prejudice on my bank application cards. The girl said, "What does that mean?" I said, "That means I'm not prejudiced. I like everybody, black, white, pink." She said, "That's so nice." And so, but the bank lawyer called me up and said, "Hey, come back and give me a new one because I can't put this one in with that on it." Because you reserve your rights. You use those words, and you see without prejudice, you reserve all your rights in law and equity.
Does 1-207 work?
Yes. But again, 1207, don't even put the statute. Just put without prejudice. That's all you need to put.
Or all rights reserved, does that work as well?
Yeah. Yeah.
Tell your story, Rob.
Oh, I am. I was contacted recently about for a student loan debt consolidation because I went, was in college for 12 years studying all kinds of stuff. Professional student for a long time, yeah. So I acquired a not an outrageous student debt, but I have student debt. So I was contacted by these debt consolidation people. And so I thought, okay, well, this might be a good idea. Consolidate it all into one bill, make it easy to pay off, and I get all the I get all the stuff that I get normally. So I said, okay. I found one I liked, and I said, okay, I'll do your program. And got their application and filled out all their application with all the information on it. And then at the bottom of that, it asked me to sign it. So at the bottom, I signed my name and put all rights reserved. and sent the application off. And about 2.5 or 3 weeks later, I get a call from him, says, oh, well, we have a problem with your application. I go, well, what is it? She goes, well, you wrote all rights reserved here by your signature. We can't process this with that on it. I said, well, why not? She goes, oh, well, we just can't. Can you sign us? Can you give us another one without writing that on there? I said, no, I can't. Any signature or contract I enter into, I reserve all my rights. Absolutely, can't do it otherwise. She goes, well, I don't think we're going to be able to help you here.
And the reason you've without prejudice or rights reserved, you're reserving your common law rights. Now, the judges you go before, if you go before court, it's not a common law court. It's an administrative court. And there it's equity or admiralty. And there's no constitutional protection there whatsoever. They cannot give you any rights there. If you have those rights reserved, they can't hear the case. They've destroyed their own jurisdiction. So it's important to use that.
Traffic tickets, huh?
Yeah, traffic tickets is another one. That's administrative law.
Passports. Very important to sign your passport, all rights reserved.
Yeah, and in fact, I would do that in everything you be careful with everything you maybe isn't true, but if you want it in court as evidence, then you can't sign that because the judge can't use it as evidence. So some things you may want before the court as evidence. For instance, somebody called me, if they would call me and say, Mr. Stamper, I just I'm here to collect your debt, so you owe the First National Bank or so-and-so. I took over the account. I said, you what? You paid that account off? God bless you. I couldn't do it. Thank you, and hang up on the son of a bitch. He'll call you up in 20 minutes and say, wait a minute, you owe me the money. I said, wait a minute, I don't understand. Do you have a contract to sign with you? I have no contract with you. Hang up again. These people, like when they sue, especially in New York, they do a lot. These bill collectors, they buy all these debt, and they go around and try to collect all over the country from New York City. And they'll send a letter to you, a real nasty letter or a phone call. We're going to sue you. And sometimes they'll sue you. Try and collect the money. They'll hire a lawyer down in Jacksonville, Florida, to sue you in Florida. And the first thing you would do is check with the Secretary of State to see if they're registered to do business in your state, the individual who's trying to collect it, not the lawyer. And if they're not registered to do business in your state, you move for a motion for dismiss for lack of standing because they must be registered in your state or they don't exist legally. They can't sue you. And all these people, I guarantee you, they're not. These collection agencies are not registered to do business in your state. Yes?
Kath and I had some financial problems about a decade ago, and there were some notes out there that we weren't able to pay. We went through a Chapter 14 bankruptcy, and we didn't actually go all the way through it. We cut it off at 2 years, 11 months. It's supposed to be a 3-year thing. And so I just cut it off right at the last month, which meant that the bankruptcy trustees sent out collection letters basically releasing, they sent it out to all of the creditors that we listed on our bankruptcy and said, you can go after these guys now. Well, we had 14 creditors, and when the trustees sent out the letters, he put my return address on it, so that they wouldn't go back to the trustee and people wouldn't respond to the trustee, they'd respond to me. Out of 14 letters, 13 came to our house undeliverable. So 13 of the creditors weren't available after 2 years and 11 months.
Yeah.
Okay, now, this is like, again, 10 years ago. And then suddenly we get this thing from Bordeaux and Associates, like you said, this was in New Hampshire, and they're trying to collect on one of those old credit card debts. So I wrote them a letter. Saying, this is all the letter right there, regarding your letter, da-da-da-da. I do not know who you are. I have no contract obligations with you. This debt is in dispute. Please provide me with the original contract with original signatures. As per Fair Debt Collection Practices Act, you are hereby ordered to cease and desist all phone calls to me. If you wish to communicate with me, do so by mail exclusively. Okay? So, now, this was 1 month we sent this out. Again, notice its return receiver says requested, and I've got the card right here, etc. It was all delivered, right? So then, now this is computer-generated letter, right? So 1 month goes by, we get another one. I do not know who you are. I have no contract obligations with you. This debt is in dispute. I have a certified mail receipt indicating you received my last letter disputing your claim in a timely manner. You are obviously ignoring my dispute in violation of the Fair Debt Collection Practices Act. If you do not have the original contract with original signatures, I order you to stop sending me the same inadequate letter. Please provide me with the original contract and original signatures as per the Fair Debt Collection Practices Act. You are hereby ordered to cease and desist all contact with me. This is, let's see, this was 12/13 last year. like a year ago.
Yes, I probably would
Heard
have.
from
I
them
probably would have
since?
followed up one more letter and told them you have damaged me now because you
That was
disregarded my
gonna be
first
my
notice,
third one.
and now this is my damages and this is what I expect to be paid and this is what and then as soon as you send that to them in demand, and then you send them a default 30 days later, and then you take them to court and you've already won.
Right, you've charged, right?
Yeah, you've already won.
Yeah.
Yes.
Can you have them put on that letter under penalty of perjury? See if they'll sign it.
No, I was going to do that with the third one. I was going to go, I was going to charge them for my time.
Yeah, you would have won too.
Yeah.
Okay, let's go ahead with okay,
No,
with
we
the
should
probably go.
We should
We should
go
go?
in about 4 or 5 minutes
Okay.
so we can walk down.
well, we'll start here. Back on we'll start here at there was been a federal fiction. We'll start in the middle of page 41.
Since we got a few minutes, Mel, and we're talking about the 14th Amendment and citizen status. I was reading really fascinating articles recently by Lysander Spooner. And in relation to the Constitution for the United States of America not being signed, therefore not having any force and effect. In a nutshell, what do you have to comment on that?
There's certainly some legal arguments that it was never signed, only witnessed. And again, I recognize that in my professor that they were just witnessed. There was no principle signed, but it's been taken for so many years that we are beneficiaries of that contract. But I think it's just it's probably a failed legal argument to even make because it's been so many years people have relied upon it, and that outcomes have been based and predicated upon it. So I think it's a contract we can say we're beneficiaries in perpetuity with it.
Of course, he wrote that at a time when it was a valid argument in the late 1800s, right?
Yeah.
In fact,
Right.
right around the same time as the 14th
Yeah,
Amendment. around the
those
Civil
things,
War.
and he was right. Texas, but now so many years have gone by that they've accepted it as being a foundation document. And all
Yeah.
court decisions have been based upon that.
That's what the Supreme Court ruled about the 16th Amendment, that it wasn't ratified. And then, and after that, they ruled that since by use and custom, the American people have indicated a willingness and a desire to abrogate their rights, that the state, the police, the courts, et cetera, can all assume that the citizen has waived their rights unless they specifically reserve them. Because by use and custom, we've allowed our rights to go by,
Yeah.
we have to reserve them preemptively.
There's something called the law equitable estoppel by leches, which means that rights left long unintended are lost.
What's it called?
Equitable estoppel by leches. L-E-C-H-E-S.
Do we need to accept the original organic constitution by affidavit and get it recorded in the county to make it a part of our?
No. No, it's that again. The courts have all accepted that as foundational law in this country. All Supreme Court decisions have said that. So it's been accepted and been well documented. It becomes common law now. It's part of our common law. That's a waste of argument.
One, that third paragraph down. Okay, there has been created a fictional federal state within a state. See Howard versus Sinking Fund of Louisville and Swartz versus O'Hare TP School District. These identify fictional state within a state. This fictional state is identified by the use of a two-letter abbreviation like CA for California, AZ for Arizona, and TX for Texas, as distinguished from the authorized abbreviations like CLIF and AIRZ and TX. This fictional state also uses zip codes, which are within the municipal exclusive legislative jurisdiction of Congress. We'll stop there for a second. I was asked to do a memorandum of law for an attorney whose client was charged with mail fraud. And going back and checking the congressional records and documents, I discovered that the post office was never granted the authority by Congress to deliver mail anywhere in 50 states, only in their territory in Washington, D.C. So all the mail that was sent out to anyone was in fact sent illegally. Therefore, they were no more than a regular private proprietor like UPS would be. So therefore, they cannot be charged with mail fraud, because mail required the U.S. government to be in charge of it. Congress never authorized, even though Article 1 authorizes them to create a postal service, they never did it. Unless Congress does it, they don't exist. That's why whenever you use the artificial numbers like two-letter abbreviation used in Congress's designation rather than your state's designation, and use a zip code, which is a
Federal zone.
is a federal zone. So before 1960, I think it was 60 when they changed it, went to zip codes. They discovered their mistake, so they give a zip code. And if you apply a zip code, that's a municipal designation under the Buck Act. And so they do that to try and get you into the trap. So whenever I have mail, if to the state locations, I have an address in Florida. That's my home address, and it's always I spell Florida out, and I don't use a zip code. The mail always gets to me. Now they may put a zip code in the post office, but I didn't put it on.
If you're mailing between people, you can do it for 3 cents.
Yeah, if you
Yeah.
use the general delivery.
Yeah.
Yeah.
Well, we've had limited success with it. We did a pretty extensive experiment with that, and we found that about
Half the time.
half the time or less, it wouldn't get delivered, or would come delivered posted pending, or things like that. So,
The 3 cents, you mean?
with
Yeah.
the 3 cent.
Or the zip, is that left, okay.
So, does indicating postal zone or putting brackets around the zip
No.
code or any of that? does that
People,
do-
the patriot community started that. Whenever in contract law, if you put brackets around an element of the contract, it's out of the contract. If you box something that's not in the contract, they're using that and they're saying that nullifies it. That doesn't nullify anything. No, just that's another patriot myth. I would just stay away from. Just don't use it. Your mail will still get to you. It may take a little longer. So what?
Okay, so we send a lot of mail. Okay, a lot of it, we send, either priority or return receipt, so it's got to go through the clerk. But if the clerk writes the postal zip on there,
You didn't do it.
you didn't do it, so then you're okay at that.
Right.
Okay. Then my other question was, in this mail fraud case that you just alluded to, were you successful?
Yeah, they dropped the case. They dropped the charge.
Dropped the charge. Interesting.
But now they fixed it.
No, they haven't fixed it. They haven't. In fact, there's a lot of things they haven't fixed. They've tried to do it, but they can't unring a bell. For instance, Ohio. Anybody from Ohio here? Anyway, when do you think it came into the union?
Say again?
When do you think it came into the union?
Never has.
Hold on, I can tell you, or at least I can tell you what I've been told.
1837.
Okay, that was supposed to be their. I was in Ohio and asked them. They were having the bicentennial. I said, "Are you really proud of it?" Yeah. I said, "Well, it didn't happen until 1954."
Oh yeah, this says 1803.
Yeah, 1803 was they're supposed to be. Well, Congress was authorized to, but they never did it. And if Congress doesn't do it, they're not there. So 4 presidents who came from Ohio, everything they did was illegal because they weren't presidents. They were from foreign country. They weren't U.S. citizens. Therefore, they could not be presidents. So everything they did, which is Howard Taft, Wilson, all these people who came from Ohio, everything they did, the Federal Reserve Act is illegal because he was not president. He can't sign it off into law. And so they can't unring a bell. What was done is done. Yes.
Now, why is Ohio not part of the union?
Because Congress never authorized it. They never voted them in. They thought they did.
1954, did you say?
Yeah, then all of a sudden they discovered the error, and all of a sudden Dwight Eisenhower, along with Nixon, came and said, "Oh, folks, inadvertently we forgot to do that in 1803. However, we're going to do it now, retroactive back to." Yeah. So, but again, you can't unring a bell. Once it's done, it's done.
But they're going to apply it. I mean, just like you say, the zip codes and things like that. I mean, if you want to go back and we were just talking about the Constitution, that it's been used and applied for all this time. So, I mean, does it really make a difference whether you...
Yes, if you put it on, it makes a difference. If they put it on, you don't care. You didn't do it.
So,
Don't put yourself voluntarily into their system.
as far as receiving mail, if someone addresses mail and using that federal zone number.
You didn't do it.
Okay.
Just don't you do it.
And if they send you a pre-addressed envelope and you re-mail it back out, you have to cross it
That's
out.
their pre-address. You didn't do it. They did it. Don't do it yourself.
Now, what about us here in the office sending stuff out?
I would probably keep doing it like you are, because
It's a fine point.
it's a fine point, and I don't think I get into it. It's not necessary.
The way Keith Anderson said it is, sovereignty will not be achieved by punctuation.
That's true. Okay, I'm going to show you a little something before you go ahead. Again, we're explaining the Buck Act and how it affects us by taking the whole country as a plastic overlay and saying we're all federal areas because of the Buck Act and the Social Security system. Now, whenever Congress under Article 1 has certain enumerated powers that we granted to them, that they have a right to legislate for us, the 50 states. They have a right under Article 1 under certain things. On Article 4, they have also certain rights for their territories. It's called plenary power or king's power. They can do whatever law they want to. without regard to the Constitution. Now, Congress knows that they have two distinct responsibilities. So when they legislate for law in Congress, if it's for us, they're very clear and very specific. And it starts out as a bill, a resolution. Now, when it's for us, we the people, it's HJR. This is HJR, House Joint Resolution 438. And this one here was 1992, and it was to get rid of the, let's see, which was for the, I believe this one was for,
Was that what year is that?
this is 1992. I'll think of what it was for in a second here. Anyway, it passed. And that means, no, it did not pass. This was 438 was the joint resolution. This was given the Second Amendment. Repeal the Second Amendment and didn't make it.
Repeal the Second
Yeah.
Amendment?
HR 666, this was the exclusionary rule. An exclusionary rule is something that if a cop stops you for a taillight being out, and he searches your car and finds a body in the back seat, he charges you with murder and all kind of stuff. Well, the exclusionary rule prohibited the evidence being introduced in court because the stopping for a traffic infraction would not be sufficient evidence to open your trunk up and look and search. Therefore, the exclusionary rule would prohibit them using that as evidence. So they modified the exclusionary rule in the federal system. So it no longer has the weight it used to have because of this House Resolution 666. But this was for their law. This applies to federal law, not to the states. States' exclusionary rule still is intact in most states. But that's how. So they know they have two types: HJR when it's for us, and HR when it's for them, their area. And
House resolution would be like an internal memo to themselves.
yes, and they don't. It doesn't have to be approved by the Senate or the President to become public policy. But HJR must go through both houses and be signed by the President to become law. And it must be, once that happens, there's several other obstacles they must have. If it applies for us, it must be recorded in the Federal Register, according to the Federal Register Act. It must be, and theirs is not required to be, but ours must be. It must also have a regulation to enforce the statutes. If it doesn't have a regulation that's in the Code of Federal Regulations and the Parallel Table of Authorities, then it doesn't apply to us. It applies to their people, but not to us. So those obstacles they must do. Now, the first thing you do, I was PQI had a meeting down in Dominican Republic, and I was supposed to go a couple of years ago, and I told Ralph I couldn't go because I had a previous appointment down in New Mexico with two lawyers who had people charged with federal crimes, drug violations, and they had heard about my jurisdictional arguments and wanted me to come down and spend some time with them. So I went down to these lawyers who've been practicing in federal court now for 15, 20 years, and they never challenged jurisdiction, ever. Had never challenged it. After that week-long experience with them, they challenged it and did a habeas corpus. Both their clients went home for Christmas. Boom. Because the federal government has no jurisdiction to apply federal law in the states. And in most cases. There's some exceptions, and we'll get into those later on. So remember, Congress is very limited in its authority to make laws for us. This entire scheme was accomplished by passage of the Buck Act to implement the application of the Public Salary Tax Act in 1939 to workers within the private sector. This subjects all private sector workers who have a Social Security number to all state and federal laws within the state, a fictional federal area, overlaying the land in California and all other states in the Union. And in California, this is established by California Form 590, Revenue and Taxation. All you have to do is to state that you live in California. This establishes that you do not live in a federal area, and that you are exempt from the Public Salary Tax Act of 1939, and also from the California income tax for residents who live in this state. The following definition is used throughout the several states in the application of their municipal laws, which require some form of contract for proper application. This definition is also included in all the codes of California, Nevada, Arizona, Utah, and New York. In this state, or in the state, means within the exterior limits of the state, and includes all territories within such limits owned or ceded to the United States of America. This definition concurs with the Buck Act, which states, the term state includes any territory or possession of the United States. The term federal area means any lands or premises held or acquired by or for the use of the United States or any department, establishment, or agency of the United States in any federal area or any part thereof which is located within the exterior boundaries of any state shall be deemed to be a federal area located within such state. The history. Before the United States existed, there was no legal government. A group of representatives, acting in the name and by the authority of the good people of these colonies, declared the independence of the colonies from the British Crown and the state of Great Britain. From the beginning, in the 1776 Declaration of Independence, the people were acknowledged as the source of authority, i.e. the sovereignty which authorized the Declaration of Independence. Next came the 1778 Articles of Confederation. The states that existed by the authority of the people created these articles while in Congress assembled. That didn't work as well as expected. In 1787, the people themselves came forth to ordain and establish this Constitution for the United States of America. On September 17, 1787, the states held a convention. All those present unanimously joined in. Therefore, in 1787, unanimous concurrence was achieved and the Constitution was born, later to be ratified. The preamble defines the context in which the remainder of the Constitution must be interpreted. After the Declaration of Independence, but before the ordainment and establishment of the Constitution, the people of the United States pretty much handled their own affairs using the common law. They were not subject to any higher authority other than the authority of the common laws administered by the people themselves, self-governance. Although the states did exist, they only existed by the authority of the people. Every man and woman were collective sovereigns, and none had any subjects other than themselves and regulated only by God's law. Upon declaring our independence, we all became sovereigns and members of the peerage nobility. The people of this state, as the successors of its former sovereign, are entitled to all the rights which formerly belonged to the king by his prerogative. Through the medium of their legislature, they may exercise all the powers which previous to the Revolution could have been exercised either by the king alone or by him in conjunction with his parliament, subject only to those restrictions which have been imposed by the Constitution of this state or the U.S. The enabling actions in the preamble are significant because there is simply nothing in the use of those words to imply that the people relinquished any of their own power and authority. People declared the law, ordained, without taking away from themselves the authority to declare law again in the future. The people established the Constitution without taking away from themselves the authority to establish anything else in the future. In other words, the people gave birth to the Constitution without giving up any of their own power and authority. What was before continues to be so today. From the context of the preamble, one may conclude that the laws of the United States do not apply to the people. The people, as ordainers and establishers of the country, are sovereigns of the country, may not be involuntarily subjected to the laws of the United States. Because of Amendment 10, the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. The government has no authority and cannot assume any authority over the people. Government powers may not reach beyond that which is constitutionally granted. What if the government to subject people to its law, it is necessary for the people to relinquish their sovereignty? Sovereignty is a natural right, which cannot lawfully be relinquished involuntarily. The subject himself must accomplish any removal of sovereignty voluntarily. Definition of a citizen of the United States. History. Before ratification of the Amendment 14, there was no legal definition of the term citizen of the United States. The term was used, but only generally. After the Civil War, the slaves were freed, but there was no legal basis to recognize them as having any rights. Amendment 14 partially solved that problem. Free the slaves was a rallying cry combined with the Civil War that resulted in Amendment 14. Amendment 14 created a new class of person called citizen, lowercase c, of the United States. Any ex-slave could now claim citizenship, and by the way, so could any of the people if they so chose to do. Amendment 14 made possible the voluntary relinquishment of personal sovereignty. It was also during the mid-1800s that the various governments took control of the school systems. The curriculum shifted from civics, the study of natural rights and common law, to American government, the study of civil privileges and statutory law. Emphasis was also refocused on good citizenship. To blunt the people's perception, civil privileges were called civil rights. The transition from teaching natural rights to teaching civil rights took about 100 years, from the 1850s to 1950s. During the 1950s, the school systems changed the courses named from civics to American government. Hardly anyone now is aware of the subject of civics as a school course. The phrase citizens, lowercase c of the United States, is defined in the Constitution for the United States of America, Amendment 14. Amendment 14 reads, Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state and where they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 5, the Congress shall have the power to enforce by appropriate legislation provisions of this article. Now, I always like to take a sentence and tear it apart by structurally looking at it. The structure of Amendment 14 is who, all persons. Qualification, A, born or naturalized in the United States, and B, subject to the jurisdiction thereof. Purpose, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor denied to any person within its jurisdiction the equal protection of the laws. Enforced by the Congress. Enforcement method, legislation. Now, quantitative analysis of Amendment 14. As discussed above, the people are sovereign. The people are not subject to the jurisdiction of the federal government. Amendment 14 inverts the relationship. One of the qualifications to be a citizen of the United States is that one must be subject to the jurisdiction thereof. It's important to understand that this is a vectored qualification. In other words, it is possible to be a citizen of the United States without being born or naturalized in the United States or subject to the jurisdiction thereof. However, if you are born or naturalized and if you are subject to the jurisdiction, then you automatically qualify as a citizen of the United States. From the point of view of the federal enforcers, the qualifications are not vectored. They reverse interpret Amendment 14 as saying that if you are a citizen of the United States, then that automatically means that you are totally subject to its jurisdiction. Judicial branch does not share this opinion. Now, when you look at 14 CJS, CJS stands for Corpus Juris Secundum. That's a legal encyclopedia, and you really want to start using that a lot because it's very informative. I have a whole set at home, and I've started reading it. I'm down to E now. I've read A through E. I hope to get to Z before I die. But there's so much knowledge that's in those, that's the Corpus Juris Secundum. It just overwhelms me. Every time I read it, I learn something new. Corpus Juris Secundum.
They don't sell it on barnesandnoble.com.
No, it's large. It's a large volume. You can buy it for used books. In fact, mine was bought through used books. One of my students bought it for me. There's 101 volumes, and it's everything you want to know about law.
Got to get a new bookcase.
Yeah. I had to move to a new house. I have a whole house just full of books. The particular meaning of the word citizen, lowercase, is frequently dependent on the context in which it is found. And the word must always be taken in the sense which best harmonizes with the subject matter in which it is used. Now, this is right out of Corpus Juris Secundum. One may be considered a citizen for some purposes and not a citizen for other purposes, as, for instance, for commercial purposes and not for political purposes. Therefore, a person may be a citizen in the sense that, as such, he is entitled to the protection of his life, liberty, and property, even though he is not vested with the suffrage or other political rights. All those are the cases that they brought out to read. In any case, if you fail to object to the government's view of citizenship, then you will most certainly be subjected to the laws of the government. That means no rights, only privileges. To see a list of privileges granted or denied to the citizens, there is no list for the people's natural rights because the people automatically have all rights. One must look to the federal civil rights laws of 28 U.S.C. 1983, 1984. One of the people, person, or one of the citizens. The first issue to be resolved in any court proceeding is that of jurisdiction. Does the one entity have jurisdiction over the other entity? One should never go into court without a clear understanding as to whether he is there as a citizen, person, or there as one of the people. If you claim that you are a citizen or person of the United States, then it is strongly implied, though not necessarily true, that you are subject to the laws of the United States. On the other hand, if you are one of the people, then it is legally implied that you are a legal king, with sovereignty superior to that of the United States, and subject only to the common law of the other kings, your peers. In short, the people are superior to the government is superior to the citizens. This is a hierarchy. People, government, and citizens. As a king, you are entitled to all the rights which formally belong to the king by his prerogative. You can do what you want to do when you want to do it. You have your own property and your own courts. There is no limit as to what you may or may not do other than the natural limits of the universe and the sovereignty of the fellow sovereign. You should treat the other sovereign in accordance with the golden rule, and at least, very least, never harm him. Your sovereignty stops where the other sovereignty begins. You are one of the owners of the American government, and it is their promise that they will support your sovereignty. They have promised to support the Constitution and protect you from all enemies. You have no allegiance to anyone. The government, your only public servant, has an allegiance to you. When you say the Pledge of Allegiance, don't say allegiance. Say instead loyalty. As a citizen, you're only entitled to whatever your sovereign grants to you. You have no rights. If you wish to do something that would be otherwise illegal, you must apply for a license giving you special permission. If there's no license available, and if there is no specific permission granted in the statutes, then you must apply for a special permission or a waiver to do it in order to do it. Your only allegiance is to your sovereign, the government, and your sovereign's mandate that allegiance to law. The government, through not absolutely sovereign, is sovereign relative to you if you claim to be a citizen of the sovereign. Here's a typical example. As one of the people, you have a right to travel, unrestricted upon the public highways. You have a right to carry guests with you in your automobile. You have a right to own a gun, and your servant, the government, shall not impair that right. You have a right to a grand jury indictment and a trial by jury that is a trial directly by the people, not the government. As one of the citizens, you may not travel by automobile unless either you are a licensed motor vehicle driver or you are a passenger with permission to be on board. Gun ownership is a privilege subject to definition and regulation. You do not have a right to a jury trial at all, in all cases, and no right to a grand jury indictment. A trial is a trial by the government, not the people. This is a memorandum of law on citizenship status. This memorandum will be construed to comply with provisions necessary to establish presumed fact, Rule 301, Federal Rules of Evidence, and attending state rules. Should interested parties fail to rebut any given allegation or matter of law addressed herein, the position will be construed as adequate to meet requirements of judicial notice, thus preserving fundamental law. Matters addressed herein, if not rebutted, will be construed to have general application. Possibly hundreds of defendants have heard lawyers say that you cannot raise any constitutional defenses concerning their taxes in the courts. This is true with regard to challenging the power to tax and the validity of the tax law themselves. The correct inquiry is, does a particular revenue law apply to the defendant? The liability for taxation depends upon a citizen's correct status under the Constitution. The defendant cannot assert or defend that status without a full understanding of it by this court. This memorandum is in support of the defendant's citizenship status. If the defendant did not understand his status, very likely he would surrender the protection they could afford him. Historical perspective. In 1776, we had 13 colonies comprised mostly of European immigrants who were sick and tired of being directed by an English government too far away to be concerned with local problems. King George was also too greedy for the wealth of the colonies to leave them alone. The king failed to provide a reasonably adequate supply of currency for trade to be carried on, and the colonists developed a kind of colonial script, a debt-free currency, which sufficed to allow local commerce. However, the bankers of Europe viewed this development with great alarm. They had worked very hard to create their privately owned central banking systems. The English government was persuaded to outlaw the script. In due course, this placed a stranglehold on local colonial trade. The abolition of script was one of the major causes of the revolution, not a tea tax as most believe. Obviously, the revolution succeeded. However, it is critical to recognize that when the treaty with England was established, the peace was made, it did not grant independence. It would recognize that independence already existed. Also significant is that the Declaration of Independence actually recognized the inherent truth that all men are created equal, in an era when inequality was universal and virtually no one was truly free. Remember, at this time, there were thousands of slaves in the colonies. In slaveholding states, none of them were considered in the Declaration of Equality and that Declaration of Independence. However, it was recognized that many of the black people were partakers of the benefits of the Revolution and the Constitution which followed. When the Constitution was adopted, free men of color were clothed with a franchise of voting in at least 5 states and were part of the people whose sanction breathed into it with the breath of life. That's United States versus Rhodes. The colonies were declared to be free and independent states. Nothing was said about the United States at that point. It was not until 2 years later, in August of 1778, that an official confederation was formed and the states were united. Its articles specifically recognized state sovereignty in Article 2, which merely prevented these independent state entities from being swallowed up by the Confederation. The American concept of sovereignty and government will be expanded on later. This confederation might have continued indefinitely, except that the new states kept charging tolls and trade imposts on each other. Foreigners could use their ports and facilities and deal with them as competitors with impunity. There was no army formed to protect these commercial interests. Without his commerce protected, the new confederation was doomed to collapse unless something was done about it. A group of businessmen and attorneys from each of the states gathered together in secret to draft something to overcome the problems. To pull off this ambitious goal, these men knew that they had to be very careful with the rights of the people and the independence of the states. To ensure public acceptance, the framers acknowledged that the proposed Constitution for the United States of America was to be a document of we the people, not of the states. It was also to become a compact which provided for the people to be its beneficiaries in perpetuity. It was intended as a compact between the individual citizens on the one hand and the people as a whole acting through their representatives on the other hand. It was a compact drawn between the people, but effective between the states. This compact created a union of states, not a union of people. People are not members of the union, only the states are members. This is a critical concept. One is a citizen of his state. National citizenship is derived from state citizenship. Implicit in this process is the recognition that the true sovereignty was not with the states, but rather with the people as a whole. There was a proposition proffered by some researchers that because all signers of the Constitution are dead, the instrument itself is dead. This preposterous proposition ignores the principles of third-party beneficiary contract, which endows non-parties to the instrument with its benefits. They receive those benefits unless they reject them. This is the essence of a trust. To reject the benefits of the Constitution, one only needs to expatriate. This does not require departure from the American soil. It only places one in a resident alien status. For tax purposes, he may be a non-resident alien, which will be explained. By virtue of this compact, 3 concepts of the United States came into existence. First is the concept that the United States is a sovereign nation in the family of nations. This requires foreign governments to deal with the government of the United States of America rather than with each state or citizen separately. And second is the idea that the United States is sovereign over its territory. This refers to the sovereignty of the government over that territory which is subject to its exclusive legislation, not to the territory of the 50 states. This is usually conceived to be the political jurisdiction of the United States. Third, the term is merely a collective name of the 50 states, which are united under the Constitution. As will be shown, federal sovereignty is not sovereignty over we the people. Patrick Henry was violently opposed to the Constitution. He feared that a central government with any strength would eventually devour the freedom of the people and the independence of the states. He was opposed to giving anything that seemed like sovereign power to the central government. Sophisticated observers will confirm that his worst fears have been substantially realized. Thomas Jefferson recognized this risk and vigorously warned the framers that the Constitution be drawn so strongly that it would bind the men of government down as if by chains. He would laugh at the idea that we should teach our children to trust in government. In order to understand the intent of the Constitution, we must read its language with the meanings which applied at the time it was drafted, not by modern definitions. Keep in mind that the Constitution was a compact, a sort of contract. Everything in our system operates on a contract principle. We give something to government and get something in return. If there is no return benefit, there is no obligation. It's a basic principle of contract that the contract is not enforceable without consideration, i.e. in the form of a benefit inuring to both sides of the agreement. In America, this compact was prepared by a group which sought to establish a national government for 13 independent states. This group purported to act for the people as a whole. Representatives of the governments of the states executed the document on behalf of the individual people of the states and for their benefit. By their ratification, it would appear that the authority of the group who prepared the contract to act for the whole body of people was validated. No state and no citizen surrendered any sovereignty to any government. It was merely agreed that the national government, the state governments, and the people would be bound to obey proper laws made under the authority of that compact. They would suffer penalties if they did not obey. This is a common law viewpoint, applicable among free men. It does not make the sovereign people subject to their government. Beneficiaries of people and their descendants remain bound because the compacts, state and national, have created governmental entities pertaining to specific territories. The person who lives in the territory, either he obeys the government thereof or he's an outlaw. Let's stop there and talk about that for a second. You cannot have total freedom. It would scare me to death if I had total freedom. I wouldn't know how to handle it. Not many of us would. If we live in society, if you want to live on top of that mountain up there and howl at the moon at night and run around naked and climb trees, you're more than welcome to do it. You don't harm anybody. But to live in society where you get closer and closer to individuals, you have to give up some of your personal freedom and liberty to be able to live socially, because the last thing you want is to scream in the middle of the night around your neighbor's house. He'll probably shoot you. He has the right to quiet enjoyment of his property also. So when you live closer and closer together, and the closer you get, the less rights you have. And people in New York City and LA have very few rights because they live so close together, so compact, that they must give up some personal freedom. So people say I'm a free white Christian virgin male. May be true. But when you live in society where you have to give up certain rights, they have a right to make certain laws, even though they're not common law, to restrict some of your freedoms for the greater good of the whole community. And I think everybody should understand that. Yes?
Can I throw something in there?
Certainly.
The concept of most people think freedom and liberty are synonymous. They're synonyms. They're not.
Right.
Freedom is unrestrained activity. Liberty comes from the Latin libre, which stands for the balance scales, liberty. So it's freedom in balance. My freedom in balance with your freedom is liberty, right? So we have the freedom of the press, but we're at liberty only to print the truth. And then what that first paragraph there, you say, in order to understand the words, you have to define them as they were defined then. One of my first favorite quotes from the pastor down here at Ashland Christian Fellowship is, a text without context is pretext.
Yes, true. Good statement.
Excuse me?
You know, like I have.
Almost like before, you said you have to give up some of your rights. I have to disagree with you there. You just have to be careful not to infringe on the rights of others.
Yes. Yeah. Again, the only time.
Rights, I'm just being careful.
Sure. Now, right now, you have a right to drive your vehicle without a license. You have a right. The right of locomotion.
He knows it.
And the fact remains
They
is
don't know it.
they'll say you have to have a license. The fact remains you don't have to have a license. When I got out of the Marine Corps, I'd been flying F4s and Harriers and everything else they had to fly, and I've been several thousand hours, and I knew how to fly pretty well. So I get out and I went over and took my logbook and I rented an airplane, and I took off in it, flew around for a little while, and eventually bought one. And so for years and years, I flew around this country, everywhere in the world, without a license. Didn't have one. I never saw a cop up there ever. I was never bothered by that. Then somebody said, "You can have a license." Well, oh, okay, I better get one. I finally got one, but I didn't need one. But again, our belief systems is what we got to read the law. A little later, we'll get into section, but I'll give a little example right now.
Can I add something?
Certainly.
I just wanted to clarify, what my thought was, is my rights end where yours begin. If I live on 20 acres, your rights aren't too close to me.
There you
But
go.
if you live 50 feet away, your rights are right there in my face, so.
And so your rights may come
be
into
limited
conflict.
somewhat because of the close proximity.
Sure, you may come in conflict. You can't
Yeah.
scream in the middle of the night because his rights are being violated then. So that's
So
why.
you want to go tell that to my neighbor's kids?
Actually, what I was going to say is it's not that you can't scream in the middle of the night, it's that you shouldn't, or that you feel that it would.
Well, they have laws against that.
Others.
They have laws against that. Otherwise, we would be shooting each other all the time. We got to control ourselves when we're so closely, densely populated. We got to control those and wait. Is it my right or am I infringing on somebody else's liberty? Okay, constitutional format. The Constitution is comprised of 7 articles and 26 amendments. It sets up the 3 branches of our government, then describes the relationship between that government and the states. The remainder deals with amendment, ratification, old debts to be paid, and oaths. It also provides that the Constitution is the supreme law of the land. It is not important to review the entire document to understand this treaty, although certain portions should be explained. Article 1 deals with the structure and powers of Congress. If Congress does not have a power to legislate in some area, then generally speaking, the other branches have no powers there either. Obviously, if there's no law, there's nothing for the executive to enforce and nothing for the judiciary to interpret. Therefore, the function of Congress is to make our laws to the extent that the Constitution permits lawmaking. Article 1 also deprives the states of power to do those things for which the national government was formed. Our government is a limited government, and this is made clear by the fact that it can only act within those powers which are specifically delegated. They are called enumerated rights. Most set forth Article 1, Section 8, and Article 4, Section 3, and include taxing, borrowing, coining, valuation, naturalization, postal service, regulate trade, regulate patents, copyrights, regulate bankruptcies, regulate weights and measures, control military and militia, declare war, establish lower courts, control government property, punishments for certain crimes, and exclusive legislative jurisdiction. By this enumeration, Congress has power to make laws insofar as they are necessary and proper for the exercise of its power. The power to make laws to carry into execution the enumerated powers is separately listed. Particularly important is the power given to the government to have exclusive legislative jurisdiction over the seat of government and such other lands as are ceded to the government by the states for its military functions, in Article 1, Section 8, Clause 17. This is a power limited in its territorial scope, but not otherwise. Because this special power has no constitutional limitation, unlike the other enumerated powers, it is similar to the power of a sovereign. It is called the political jurisdiction of the United States. It operates in Washington, D.C., and all areas ceded by the states to the federal government as enclaves. A similar power operates in the possessions and territories of the United States, but it has its source in the combination of the property power, Article 4, Section 3, Clause 2, and the inherent powers to acquire territory. The power to acquire territory and the power to govern that territory is not delegated power. They are deemed to be inherent powers. As will be explained, sovereign power, like the Admiralty Law, is deemed a necessity in those uncivilized territories. What is critical to understand, however, is that such sovereign power in our government does not operate within the 50 states, except in those ceded enclaves. Delegated power over property is the power to protect the assets of the government and to regulate their use. Control over property was originally intended to apply to owned assets and did not relate to the government or territory. When what happened to the slaves after the Civil War is shown, it will be understood how this property power has become a potent weapon used by the Internal Revenue Service to enforce the tax laws. Constitutional guarantees are not generally applied in the sovereign federal areas, except insofar as Congress chooses to enforce them. Although a fundamental right should still exist since it is deemed unalienable, Congress can take the position that since we the people delegated sovereign power, all the people must be subjects in those areas because there cannot be two sovereigns ruling in the same place. Having such power, it was not hard to predict that Congress would try to expand its power beyond its proper limitations.
Would you allow me to read this? I think it would
Yeah,
explain
go ahead.
You know this one?
Yes.
This is Theodore Roosevelt speaking at the Jamestown Exposition, April 26, 1907. We of this mighty Western Republic have to grapple with the dangers that spring from popular self-government, tried on a scale incomparably vaster than before in history of mankind. So remember, he's talking about inherent dangers of self-government. It behooves us to remember that men can never escape being governed. Either they must govern themselves, or they must submit to being governed by others. If, from lawlessness, fickleness, from folly or self-indulgence, they refuse to govern themselves, then most assuredly, in the end, they will have to be governed from the outside. They can prevent the need of government from without only by showing that they possess the power of government from within. A sovereign can make no excuses for failures. A sovereign must accept responsibility for the exercise of the power that inheres in him, and where, as it is true in our republic, the people are sovereign, then the people must show a sober understanding and a sane and steadfast purpose if they are to preserve that orderly liberty upon which, as a foundation, every republic must rest.
That was from our socialist president.
No, this is Theodore.
Oh, Theodore.
Theodore, not Franklin.
Right?
No, this is Theodore.
So he's explaining, back, it was well understood back in those days. The separation between the state's power and the federal government was well understood. There were only federal, in fact, there's the Kentucky resolutions. Thomas Jefferson rode to Kentucky because Kentucky and Tennessee were ready to bail out of the Union because the federal government was killing people right and left for violating federal law, namely making whiskey. My forefathers liked whiskey, and they still make it to this day. And they were the hell with the federal government telling them to do anything. So there was almost a revolution. Many people were killed. It's called the Whiskey Rebellion. Anyway, he took a horseback and went to Kentucky to sit down and talk to the legislatures of Tennessee and Kentucky and came up with the Kentucky resolutions. Now, I studied as a kid. Most people have never seen those, except if you're from Kentucky. But he said there's 4 crimes, and 4 crimes only, federal government listed in the Constitution, that we will enforce, and no other crimes whatsoever. Those same 4 are the same 4 today. They're treason, counterfeiting, piracy, and laws against nations. Those are the only 4 laws that they can enforce constitutionally in the states.
Did you say laws against nations?
Laws against nations. In other words, if you said you can't sit and conspire in this country to overthrow another country, a group of people, there's a whole body of law against nations. Law, it's called law of nations. Huh?
Tell that to the
I said our
Iraqis.
government's doing that every day.
Sure they are.
Tell that to George W.
And his friends.
Okay, this expansion is manifestly evident in the application of the taxing power. That power is limited by the Constitution. Direct taxes must be apportioned, and excise taxes must be uniform. These limitations, however, do not apply where the government has sovereign power. Remember, while the enumerated powers, which operate all over the country, are limited by the Constitution, the sovereign power in territories and areas ceded by the states are not limited by the Constitution. By examining the revenue laws, it will be seen just how the sovereign power has been used to invade our rights within the 50 states. Congressional power over federal funds has also been used to expand government authority. This is done by virtue of the practice of the federal government placing conditions on its grants of federal assistance. After all, the sovereign citizen has a right to contract even with the government. If you sell a right, it's gone, even though inalienable. By this process, federal government has invaded every conceivable phase of our life. Regardless of the Constitution, individuals, companies, schools, districts, and states have all surrendered rights in exchange for money and present or future benefits in the form of trusts. Let's talk about trust for a second, because it's a contract, and Congress can make no law impairing the obligation of contracts. No law, N-O. So I started thinking about this and contemplating. In Florida, every time it rained, I sat down and started thinking. I always got in trouble when I did that. And so I said, if they're using trust, and I believe that they are using trust to get us into equity court, then why can't we use trust against them? So I talked to a couple of the guys in my office, and they said, yeah, let's put together a trust. So that rainy day, we put together a trust against the judges of Florida and the state and the police officers of Florida. And we call it the Florida State Retirement Trust Fund for judicial officers and police officers. And we created this trust with articles. And one of the articles said that no police officer in the state of Florida has the jurisdiction to stop and hold the trustee of this trust for any violation of traffic infractions. And then no judge, as a beneficiary of this trust, has the jurisdiction to hear any case against the trustee of this trust for any traffic violation, et cetera, et cetera. And we put this together, and we did it. And we went and sent them a check of $500 to each retirement fund. And it was cashed and sent back to us.
Whoa.
And we forgot about this for a year or two. And then one New Year's Eve, one of the lawyers got drunk and got arrested for drunken driving. He was, I only thrown out of the bar, Mel. And I said, well, we made a trust we did a couple years ago. Let's see if it works. That's his only defense. So he said, okay. So he took it to court and said, Your Honor, I challenge jurisdiction of this court and that you're a beneficiary of a trust and you have no jurisdiction to hear this case. He gave the trust along with a copy of the canceled checks. The judge looked at it. Case dismissed. He walked out kicking his heels together. Trusts work both ways. We have all kinds of trusts.
Let me get this straight. You guys set up a trust. You made the cops and the judges all beneficiaries of it.
All the state of Florida.
Then who was the trustee?
I was.
You were the trustee?
Yeah.
Now, why $500? Why not $2?
Well, yeah. but
You
that,
have
they,
to be serious
$2 they would probably
consideration
question
with
it
that.
and send it back to you. $500 they're going to take. You know, I don't be cheap about stuff like that. I'll put it in because if it's a contract.
Accept the
It works.
donation, Therefore, they're bound by the contract.
Yeah, and that's contract law. Even if you're not aware of its existence, if you're not aware of the existence of a contract, if you take the benefits, either present or future benefits, as beneficiary, you're subject to the articles of the trust. And that's how they invaded the Constitution with us, the restrictions of the Constitution, by doing trusts. We have the Highway Safety Trust Fund, we have the Social Security Trust Fund, Airport Safety Trust Fund, all kind of trust funds that we're beneficiaries of. Therefore, we take a benefit of that trust. If we don't know of existence, we're subject to the articles of that trust.
Now, who is protected by that trust? Just your group of lawyers there? Or
Yeah.
Were you all you were the trustees?
We were the trust.
Okay.
And I was the
you couldn't-
trustee.
You couldn't create a trust that named all the people of Oregon State or?
No, that would be too broad. You have to be very, very specific about who you're targeting. But a good one to target would be judges, because in other words, that's the ones who are going to put you in jail. So if you target them and they take the thing and you're within your rights to do so, and you have break a contract, but don't say I can't be charged with any crime, because obviously I'd never hold water. But specific crimes like traffic infractions, you probably could get away with that because, yeah, they set a rule on those things. If they get the benefit,
Well, a
it's
traffic
the article.
infraction is not a crime.
Not a crime.
It's a contract.
That's right. Well, again, crimes are only crimes. There's two kinds of crimes: mal in se, which is a crime in itself, and mal prohibita, which would not be a crime at all except the legislature has created it. So those two are two law. One is common law. One is statutory law. One's vulgar law. One's common law. So all you're doing is saying, hey, if I violate a law, you can go ahead and prosecute me, but if I don't violate a law, you can't. So again, have fun with it, guys. Yeah, have fun with it. Why not? You get rainy days here, right? Sit down and do something.
It's not in Oregon.
Okay, the president has only the powers to command the military, to appoint government officers, the bureaucracy, and the judges, and to make treaties. He has a duty to adjourn Congress and to execute all of its laws. Congress is supposed to give him, not to give him any power to make new laws. What he does instead is to make regulations. In addition, under the guise of emergency powers, Congress has given him about every other power for which he could possibly ask, and those he has not been granted have frequently been seized and assumed without regard to limitations of the Constitution. The Bill of Rights is supposed to be our protection against oppression of the federal government. It was never designed as a protection against state authority. We look to our state government's constitutions to see how carefully we have protected our fundamental rights against state oppression. Supposedly, powers not delegated to the federal government by the Constitution belong to the people, except to the extent that the people in their state constitutions have given them to the states. In actual practice, the government has grabbed a lot more power and the Supreme Court has ratified the seizure. We'll find that this often happens simply because in our ignorance, we consent to the seizure. As carefully as the Constitution was drafted, it could not protect us from the wiles of evil men. The Supreme Court, as late as 1856 in Dred Scott, reiterated the limitations and prohibitions on Congress, specifically declared in Amendments 9 and 10. Undelegated powers were forbidden to Congress. However, Chief Justice John Marshall, back in 1816, had emasculated this doctrine. He ruled that anything not expressly prohibited by the Constitution, and which could be related to enumerated power in some way or to constitutional objectives, was a thing authorized to be done under the power to enact necessary and proper laws. Since the Constitution was adopted to promote the general welfare, most recent cases have decided that this includes a power to spend for the general welfare. Even this expansion cannot explain away the unconstitutional application of tax laws or spending for education, social welfare, Social Security, and foreign aid. The Supreme Court generated an equally serious problem in 1932 when it decided that any law enacted by Congress or the states was not open to challenge by anyone who had received any benefit under such law, nor could it be invalidated if there was some way to construe or apply such law in a manner not in conflict with the constitutional limitation. The citizens should be aware, however, that whenever either a voluntary act or a questionable law appears to deprive one of an inalienable right, natural right, if you are not aware of this, that such is the effect of that act or law, the individual should be able to prevent the deprivation, clearly expressed by the Supreme Court ruling, which prevents an unconscious and unintended waiver of any such right, in Bradley versus United States. Similarly, when an official violates the Constitution, he is not deemed to be representing the government. That's an important case, Brookfield Construction versus Stewart, because when you start suing these federal government agents for violating your rights, that's one of the cases you want to cite. Sovereignty and citizenship. A sovereign is one whose supreme power is vested. He can delegate whatever of his total authority he wishes. He can consent to whatever outside authority he may choose or none at all. However, he cannot be subject to outside authority. This would be in contradiction to sovereignty. The creation of the enumerated powers was done by delegation. This simply means that the power of the sovereign people remained with them, but that the federal government may do its exercise on their behalf. This relationship is well stated by the Supreme Court as follows. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. But in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts. What it means is that Americans are sovereigns, without subjects, because all of us are equal. It's important to differentiate between sovereign power and inalienable rights. Sovereign power is subject to nothing except what the sovereign expressly agrees or consents may be done. Inalienable rights are simply those rights which cannot be taken away, but they may be waived. In this context, it may be understood how the people may remain sovereign even in an area where the federal government exercises this sovereign jurisdiction. By consent or waiver, the people may be without those fundamental rights as to such areas. At least it appears that the federal government operates in that premise. Therefore, although there might be some sort of waiver of rights, there is no fiction of law which can convert a natural-born sovereign citizen of this country into a subject. This nation was formed on the basis that it had declared independence from all other authority. At that time, there was no place on earth where men were free. Individual sovereignty existed only for declared monarchs. However, with the Declaration of Independence, one who had been subject to English law became a sovereign in America. Individual Americans had already delegated some of their authority to their respective states, and each was a species of sovereign country, much as the United States is now a sovereign nation. When the Constitution was adopted, it was the delegation of authority, and it formed a more perfect union of the states. It acknowledged that citizens both of the states and of the United States pre-existed its adoption. These citizens ordained and established the Constitution, and the states consented to its adoption. The framers also recognized that the powers of the states had come not from the Constitution, but from the people. There have been complaints by members of our highest court that the application of this concept of sovereignty in the territories has in effect given rise to the creation of two national governments, one for the states, which is severely limited, and one for the territories. The Supreme Court has declared that although the sovereign power may be in Congress and the federal territories and enclaves, it also recognized that in the Union states the sovereign power remains with the people. Residual sovereignty of each state is also in the people of such state. Congress is without power to revoke a citizen's sovereignty. Decisions comparing our laws to those of England and on the continent usually admit to declare that all of these European laws apply in nations which have no concept of individual sovereignty. Their citizens have always been either subject to the king or to the government which has replaced him. None of those nations was ever declared individual sovereignty for their citizens. Because of the corruption of citizenship which came with the 14th Amendment, it is important here to examine the fundamental character of the sovereign citizen. A citizen is always a natural person. It will be remembered that a person has rights, and with those rights he has reciprocal duties. When a person is a sovereign, his basic right is his possession of absolute power. He has no superior except God. However, the connotation of sovereign carries with it an implication that there may be subjects. Duty of the sovereign to the subjects is to protect them. It has been pointed out that the sovereign citizen was basically a sovereign without subjects. We delegated some of our sovereign power so our representatives could help us protect ourselves. We gave up the powers to wage war, maintain a navy, and control our military. In addition to this sovereign body politic, we the people adopted a Bill of Rights, which prohibited our government from impairing our rights. Those rights are our fundamental rights. Our political rights to vote, hold office, and serve on juries are not mentioned in the Constitution. Political rights are basically covered by our state constitutions. Before the Civil War, there really was not a true concept of citizen of the United States. In the strictest sense, everyone was simply a citizen of the state where he lived, and naturalization was a state process. The only subject in this country was the African slave. As we will see below, the amendments which freed the slave did not make him a sovereign citizen. He should have become sovereign with the Declaration of Independence. However, white men in most states refused to allow this declaration to be made applicable to him. The Constitution officially recognized and protected slavery. When the white conscience was aroused to remedy the error, crafty men emasculated the effort. What is critical to recognize is that our original Constitution, citizenship, came by virtue of our being state citizens. The Constitution did not create it. Thus, except for those who elect to claim citizenship thereunder, Americans do not look to the Constitution for their citizenship. It is officially recognized that our state citizenship is a thing which is separate and apart from our national citizenship. Quote, this is from the United States versus Cruikshank. There is in our political system of government of each of the several states and the government of the United States. Each is distinct from the others and has citizens of its own. So what's the meaning of national sovereignty? National sovereignty is a fiction. It operates in our relations with other nations, since other nations simply cannot comprehend personal sovereignty and will only deal with a national entity. Similarly, state sovereignty is an expression used to separate the powers and rights invested in states by delegation from those invested in the nation, as recognized by the Constitution. The only real sovereignty in this country is personal sovereignty. Thus, it logically follows that where any decision declares the powers and immunities of sovereignty which apply to a state or the national government, then a fortiori that declaration ought to apply to a sovereign citizen. Similarly, since there can be only one sovereign authority operative in a specific place at a particular time, The fortiori means that if it applies to this set of facts, then even more so it should apply to this set of facts. The term foreign country, when used in a geographical sense, includes any territory under the sovereignty of a government other than that of the United States. That's in 26 CFR. CFR means Code of Federal Regulations 1.9112H. As already explained, the sovereignty of the federal government extends only to those areas ceded by the states or acquired as possessions and territories. Our Supreme Court has explained that enclaves within a state are like the territory of a sister state or a foreign land. Even national parks, such as Yosemite, is deemed to be under a distinct sovereignty from that of California. In view of the fact that it is the citizens who are sovereign, we are entitled to wonder where our government ever got the idea they can claim sovereign immunity from a suit by citizens. The law was once clearly stated that there is no inherent sovereignty in the government of the United States. Federal immunity from suit lawfully can only be available as against a citizen who is subject to the federal government. That is the type of citizen whom shall be clarified when the Civil War amendments are examined. Inalienable rights. Inalienable rights are those which belong to a man because he's a man. However, before we developed the idea of a sovereign individual or a sovereign citizen, only monarchs enjoyed such rights. In our nation, they're considered to be so fundamental and basic to humanity that there is no humanity without them. Obviously, in the days of slavery, those who were slaves did not have any rights, unalienable or otherwise. The censure on human nature merely points out man's inhumanity to man. It does not change our history, nor the legal effects of history and our institutions.
I think that's really important.
Yeah. The Declaration of Independence characterized life, liberty, and the pursuit of happiness to be included among our inalienable rights. Southern white people simply did not consider blacks to be men. They were property. There were many who disagreed even in those days. But in order to secure unanimous approval of the Constitution, it was necessary to insert compromise provisions which protected slavery until 1803. However, it took 90 years before the country was ready to recognize the injustice. To rectify it all still remains to be done. Even after the Civil War and the supposed freedom of the black man, federal courts seemed to tacitly recognize that certain citizens were not free because only free citizens were held to have inalienable rights. In reading the Constitution, remember that it is we the people who are doing the delegating and the reserving of rights, not the government. This is evident from the amendments which reserved undelegated powers to the people and the states. Not all inalienable rights were listed either in the Declaration of Independence or in the Constitution. Only those rights which had been blatantly abused by governmental authority and colonial experience merited special mention. They dealt with such things as administration of justice and personal freedoms, Amendments 1 through 8. Property rights were protected against seizure without due process of law and just compensation, Amendment 5. And contracts were protected against impairment, Article 1, Section 10, Clause 1. However, the scope and nature of those rights was left to the state definition under the general category of fundamental rights. The importance of the distinction arises when it is understood that although fundamental rights have general constitutional protection, they are recognized in the federal enclaves and territories only to the extent that Congress chooses to recognize them. The entire Bill of Rights is merely an expression of our intention to be free from endless burden of endless political laws, which merely restrict and regulate our lives. Constitutions are not made to grant rights, they merely recognize rights and limit the power of government. It was never intended that the career politicians would people Congress, who would spend each year dreaming up laws for us. On the contrary, the Constitution contemplated limited lawmaking. To be sure that the legislators would simply not forget their elected duties, they were required to meet in session at least once a year starting the first Monday in December. However, by 1933, legislation had become big business. Congress managed to obtain an amendment to have the mandatory session start on January 3rd each year. We must realize that specification for fundamental and unalienable rights depends upon where you live and what form you are asserting such rights. While they are all deemed to be inherent and to exist independent of any constitution, amendment, or law, if your particular state, territory, or court chooses not to acknowledge any such right, you may as well not have it. Fortunately, the rights spelled out in the Bill of Rights seem to be enforced in every type of American court, so long as they are not regarded as waived. That protection is rather hollow, however, as a defense against taxation. This is true because the original Constitution, exclusive of the Bill of Rights, protected no fundamental rights against federal invasion. It merely required the states to give equal treatment to the citizens without regard to the state from which they came. The Bill of Rights purports to limit the federal government in its powers, but only to the extent specifically designated. Theoretically, our federal government is restricted by all our fundamental rights. In practice, this protection is invoked only when the court finds it expedient. The Bill of Rights left the states just where it found them, added nothing to the power of government, and took no power away from any state. It was strictly a control device against oppression by our central government. In fact, with the exception of two amendments, Amendments 14 and 16, none of the amendments grant anything. They simply prohibit certain types of legislation or conduct. Unalienable means not subject to separation, or unalienable. However, we can separate ourselves from an unalienable right simply by waiving that right. Yes?
I was typing along in Microsoft Word, and I highlighted the word alienable, and I hit the dictionary, and it said not being capable of being transferred to another by a legal process, not commercializable. So it's not something you can sell.
Yep.
It's not something you can even assign.
Yep. Unalienable or unalienable, a lot of people have distinction between the way you pronounce it. It's just like if I'm from Boston, I say ka, or from Chicago, I say car. You know, it means no difference. It's a synonymous word. But you can't transfer it. You can't give it away. It's something that's yours, unalienable.
It'd be like saying I want to give up my right to breathe.
Yeah. Okay, the Supreme Court has given us some protection against inadvertent waiver. It has declared that a citizen does not waive an unalienable right unless he does so knowingly with full appreciation of the circumstances thereof. One who loses his rights is not presumed to be acquiesced in that loss. And certainly if we have inadvertently done any consenting to the invasion of such rights, we ought to be free to revoke such consent. While it is true that the original Constitution does not compel states to give us any rights, except for equal privileges and immunities as state citizens and interstate travelers, it does require that we have a republican form of government. This is enforced for new states because before admission, Congress reviews their constitutions. Such a form of government is itself recognition of the existence of individual sovereignty and inalienable rights. Thus, the popular fraud that the 14th Amendment is our guarantee of rights must give way to the truth that such rights were protected before that amendment existed. Courts have held that the Bill of Rights was not carried to the states by the 14th Amendment, except to the extent that any such right is independently deemed fundamental. The inherent contradictions found in the foregoing analysis of fundamental rights and their supposed protections arise not from a misunderstanding of the law, but rather from conflicting applications found in the court decisions. Civil War amendments. Civil War did not end slavery, contrary to popular views. It merely separated the slaves from their masters. These former being black people continued to be in the status of subjects. They were not even free subjects. Had they been, no 13th Amendment would have been necessary. Even after the 13th Amendment had made them free, they remained subjects. They were still ineligible for citizenship as the law was then interpreted. Since the emancipated black man was not a citizen, he became a resident alien, or simply a resident. This resident subject was a species of property, just as with ancient English serf. The 13th Amendment prohibited slavery and involuntary servitude. Nothing was said about voluntary servitude. Most bond servants from Europe had been in a state of voluntary servitude in that they had contracted for a term of service in exchange for some benefit. An apprentice had been in a similar silver estate. His voluntary agreement put him there. More whites came to America as voluntary indentured bond servants for 7-year terms to work off their passage than all blacks that came here by force as slaves. After this country was formed, the rules for the enforcement of personal service ended, and the concept of personal sovereignty for white people. However, the black man was not a sovereign. After the adoption of the 13th Amendment, he was free as to the entire world, but not as to his master. His master was the American sovereign, meaning the American body politic, we the people. The people had delegated to the government the power to administer their property. Thus, the power of the administration of these subjects was in the government, and they were subject to the jurisdiction of the United States. Even those blacks that had been freed by their masters before the Civil War were not part of the body politic, with rare exceptions. Our Supreme Court had confirmed this discrimination. Furthermore, as of 1787, every southern state had a constitution which prohibited blacks from voting or holding citizenship. Most prohibited land ownership as well. The effect of emancipation was to enable the black man to go where he chose. It was thought that he would go back to Africa, even though he had never been there. It was as native to America as any whites. Of course, America was his home, and he had no intention or desire to leave. However, this left those millions without work, without homes, and without means. They were a threat to the Southern economy. The long-nurtured attitude of contempt for black men caused the white legislators of 11 Southern states to pass laws which would guarantee that the free blacks had no rights, no jobs, no property. However, martial law was still in force. The 14th Amendment was prepared, and Congress let the recalcitrant Southern states understand that their return to full governmental power was suspended until the amendment was ratified. This was clearly duress, and the Utah Supreme Court has openly declared the invalidity of Amendment 14 as recently as 1968. However, it conceded that we must submit thereto until the Supreme Court validates it officially. The language of the 14th Amendment makes it quite clear that it does not apply to a sovereign citizen. Not one single white person owes his citizenship to Amendment 14, nor did it give any of the white man any new inalienable rights. The condition of receiving citizenship under the amendment is that one be subject to the jurisdiction of the United States. It also created a new concept of residence. The subject who had been a resident alien now became a resident citizen. Allegiance is a concept which applies to subjects, but not to sovereign citizens. It is a feudal concept which would not ordinarily apply to this country. In this country, citizenship is constitutional, while allegiance is personal. Citizenship is freedom, but allegiance is servitude. Citizenship is a political tie, while allegiance is a territorial tenure. No sovereign citizen owes allegiance to any power on earth. What we have is a concept of mutual loyalty in supporting our republic. After the 14th Amendment was adopted, cases discussed allegiance and applied the concept for the purpose of explaining the rules of citizenship by birth. For Daniel Webster has pointed out that we only perplex ourselves when we attempt to explain our political relationship by reference to European nations. Sovereignty and government is an idea belonging to the other side of the Atlantic. Sovereign citizens need no protection of inalienable rights. They have all civil rights by virtue of their sovereign character. However, as sovereigns, they have a duty to protect their subjects. The property power delegated by the Constitution originally authorized Congress to legislate to protect government property. Amendment 14 extended that power, authorizing Congress to enact legislation to enforce the restrictions against which the states were prohibited to legislate. And suddenly we find that Congress empowered to enact so-called civil rights laws. This used to be a function of the states. Did anyone but the new type of citizen need this protection? One must remember that the situs for property is somewhat equivalent to domicile for a natural person. Since the 14th Amendment, subject citizen is a species of property. Since he is subject to the jurisdiction of the United States, he may reside as a person in a state, but he will always have his situs as property at the seat of government, Washington, D.C., the domicile of his owner. Alternately, one could look at it in a different manner. Remember that it is usually an alien who resides in a place which is foreign, and citizens just live in their home state. Under Amendment 14, a new concept of residing arose. It would seem that as a citizen of the United States, all the new kind of citizens living away from the political jurisdiction of the United States would have continued to be aliens as to the state in which they resided. However, the 14th Amendment also made them citizens of that state, but continued to call them residents thereof. The amendment does not apply to the sovereign citizen. Thus, he continues to be alien to the 14th Amendment citizenship and to that special residency. He is also non-resident to the areas of the political jurisdiction of the United States. He has been transformed by the 14th Amendment into a non-resident alien, since very few sovereign citizens live within the political jurisdiction of the United States. The importance of this concept of situs for tax purposes becomes clear when we consider what the courts say about congressional intent. We think the language of the statutes clearly demonstrates the intent of Congress that the source of income is the situs of the income-producing service. While it is obvious that the black man got a form of citizenship and that he did owe a continental concept of allegiance to the federal government, that concept of allegiance would contradict with individual sovereignty. The distinction between sovereign citizenship and subject citizenship was better defined by pointing out that the latter citizen was completely subject to the direct and immediate jurisdiction of the United States. Nothing in the 14th Amendment protected any fundamental rights for the new subject citizen against impairment by the federal government. In addition, because the subject citizen has a situs at the Capitol, constitutional limitations on governmental powers have no application to him. Under the amendment, no rights were created, and the amendment merely prohibited discrimination. This was a restriction on the states, not a restriction on the national government. By Amendment 14, then, you find that the government has retained the power to regulate the affairs of the black man and to make any laws it chooses for his protection. Herein lies the secret of the tax laws. Privileges called rights of the subject citizen under the Constitution are created by law, and are only as inalienable as the laws made them. Anyone who claims rights under the 14th Amendment is volunteering himself into that same status of subjection. No wonder we are told to exercise rights under the 14th Amendment. The Bill of Rights was not imposed upon the states by the 14th Amendment. In fact, the 14th Amendment gave no benefits to white citizens. Where there's no benefit, there's no duty. Thus, the regulatory laws made for the 14th Amendment citizens create no duty to sovereign citizens. It was previously demonstrated how the revenue laws actually place a sovereign citizen living in one of the 50 states in a foreign status. Now we can understand the strained logic of this application. The federal government has avoided the restriction against legislating for the non-resident alien foreigner by the simple device of encouraging our voluntary compliance with revenue laws. As long as we sign documents having the quality of commercial undertakings and promises, we are volunteering to be subject to the entire panoply of laws and controls applicable to the subject citizen. Whenever we do so, we can hardly be heard to complain about such laws. Our own tax returns will be brought into court to demonstrate how we voluntarily assessed ourselves and promised to pay our taxes. If we fail to file a return, an old return will be produced to show that we knew our duty to file. Commercially, those tax forms reveal our power course in dealing. As will be shown, we have fully complied with procedures set forth in the UCC, which render us obligated to pay tax. Citizenship did not create any political rights for the new citizens. It was for this reason that another amendment was adopted, forbidding abridgment of their voting rights. Obviously, the entire process has seriously defrauded the black man. Whatever might have been the motivations of the men in the 1860s, in the 2000s, no reasonable person could desire the kind of differentiation which was perpetrated under the Civil War amendments. Even in 1867, it is doubtful that the public intended that there be this class distinction. It seems to have been the undisclosed idea of certain men in government, and obviously such bigots were afraid to allow blacks full rights, and hence the language of the 14th Amendment. America had an opportunity to validate the Declaration of Independence for all men. Instead, our government has used the 14th Amendment as a device to make us all equal, in fact, equal as slaves. Justice Wilson predicted this fate 200 years ago. How true it is that states and governments were made for man At the same time, how true it is that his creatures and servants have first deceived, next vilified, and at last oppressed their master and maker. Corporate government. A private corporation has no sovereign rights and exists only as a governmental privilege. Even a state in such capacity loses sovereign immunity from federal power. A fundamental precept of law is that when a government, state or federal, engages in business, the laws of business apply, as if the government were a mere private corporation. Our government has imposed upon us the private system known as the Federal Reserve System. That system uses commercial paper called Federal Reserve notes. Constitutional gold and silver have been abandoned as our legal tender. Federal Tax Lien Act of 1966 authorizes that commercial law applies, at least in tax lien enforcement. Collectively, these realities make it hard to refute the prevalent claim to the effect that our tax and money systems are governed by the same private law, which govern corporations. Thus, the claim of sovereign immunity by the courts in these areas is constitutionally unsupportable and is utterly disingenuous. This idea gains substance when one remembers that the political jurisdiction of the United States is actually limited to the enclaves and territories. Congress has created private corporations and has incorporated Washington, D.C. as a municipality. In fact, it is only under that municipal charter that federal corporations can be created. The capital may probably be called the corporate United States. It is quite evident that except for the subject citizen, the tax laws only apply to individuals and income derived from the areas under this federal corporate control. Unfortunately, the courts do not seem to understand this viewpoint. This is not surprising when it is clear that most Americans have voluntarily signed up with the government for tax payments. Those commitments are being enforced against us. It isn't unconstitutional. The Constitution simply does not apply to a person who has volunteered to pay those taxes. The popular argument regarding source income at 26 CFR 861, which exempts U.S. citizens' labor from taxation, is accurate, but it applies only to U.S. citizens, and that's not you. The more accurate argument for exemption for non-resident aliens is 26 CFR 871. In that section of the code, if you are working within or for the United States, your income can be taxed at a rate of 30%. But if you do not receive income from the United States or within their political jurisdiction, you're exempt from taxation on your compensation for personal labor. You will find that even our relationship with the United Nations is of corporate character, and that the UN included the United States as one of its incorporators, and as such dispensed with the sovereign character of the country. In effect, the UN Charter declares that our country has given up any power not set forth therein.
The point about that? Many people wanted to use the international driver's permit issued under UN jurisdiction.
Yeah.
So I went and got the charter, the UN Charter, International Charter on Road Traffic, 1946, and the first paragraph says that this law is applicable in all territories and all countries and territories under UN jurisdiction.
Under UN occupation.
Under UN, occupied by the United Nations, that's what it says. So if you're carrying an international driver's permit issued under that law, what you're doing is admitting that the United States is occupied territory of the United Nations.
Well, NAFTA and GATT treaties, the La Paz portion of the NAFTA agreement, gave 60,000 square miles of our territory to the United Nations as a buffer zone between Mexico and the United States. And every city along the border between the Gulf of Mexico, which includes Brownsville, Texas, and Lubbock, a lot of these different cities, and in Arizona, and all the way to California, 60,000 square miles of our property was given without a shot being fired to the United Nations as a buffer zone. They have territory. That's theirs under the NAFTA GATT agreements. I testified before Congress with 6 people from Florida against them to ratify those treaties. And we have spent months studying them. And it's 20,000 pages in the actual act, and 2,000 summary pages. And we told the congressman how damaging it would be to our national economy and our country as a whole. And that can't be. Have you read it? No. We're having our aides read it right now. I said, well, why don't you have your aides here instead of you? Then if they're going to read it, let's talk to them. But somebody's got to be awake here because this is disastrous. We'll be an agrarian society within 10 years or 15 years if you pass this.
An agrarian society?
Yeah. And there's been no nation of farmers who's ever been a world power. And right now, because of NAFTA and GATT, almost all of our armaments are made in some other country. We can't even fight a war with Mexico because they make all of our tanks. We'll have to go naked if we fight China because they make our uniforms and our boots. We don't do things anymore. We're shipping it all overseas to other countries, and we can't take our own selves here. We've loosened all of our industrial base in this country. We're nothing but an agrarian service economy now. We sell hamburgers to each other. That's how we're supposed to make a living. But it was a dastardly treaty.
Argentinian beef in it.
Yeah, It's a dastardly treaty. It would never should have been passed. It's treasonous, I think, in my opinion, it was treasonous. And everybody who voted for it absolutely should be put on trial for treason. Let's have a little break. We'll get back to the legal system.
So if anybody wants a soda, there's a refrigerator full of them in there.
Let's turn that off.
Attention class, you're out of control. You know, sometimes whenever I'm outside, we won't record this here. Sometimes when I'm outside in discussions with people, some things are brought up, topics that are really interesting, and I don't mind answering your questions outside, but sometimes they're so important that the whole class will benefit from that answer. So sometimes if you have questions, why don't you ask them in class as opposed to outside? I'm not opposed to it, just some people won't benefit from that thing. Now, one of the things that came up outside was 861, and also in here. 861 is the argument used by Larkin Rose and many in the patriot community as being the exemption from taxes. That fails every time because that's for U.S. citizens. For instance, if I were Eddie Kane, who had American Rights Litigators, who was a tax organization for years. Eddie and I have been friends for 20 years. He and I have disagreed for 20 years. Many things. Eddie's a hardhead. He has a good heart, but he has a hard head. When he first found out about some things, form number 2555, it was for U.S. citizens to be exempt from taxation. So he immediately went out to all of his people, 4,000 people, and said, okay, if you file this 2555 with your 1040 form, they'll give you your money back. And sure enough, a few people got it. And all of a sudden, he expanded it, and everybody started doing it. All of a sudden, they start prosecuting. 2555 is for U.S. citizens. If you lived in Washington, D.C., as an example, you don't pay federal taxes there, but you pay municipal tax in Washington, D.C. Now, if you work in Virginia, and you're getting federal tax taken from you in Virginia, end of the year you will file a 2555 with your 1040 form, and they give you all the money you earned in Virginia back. That's what it was for. U.S. citizens, not for us. We are non-resident aliens. The Supreme Court in Bushhaver versus Union Pacific Railroad told us that in 1933, that we were in fact not, Bushhaver was a non-resident alien to the federal government, and therefore he was subject to the federal taxes that he had gotten from the source. And so they coined the phrase, not me. And the fact is that case is still the case law that's decided by the federal government as well as everybody else, but they've gotten it wrong. And we'll read that in depth later on to explain why it's wrong.
Back on?
Yep. Okay, legal system.
Somebody rocking and rolling.
Judges and men. A biblical example of judgment that might put into perspective our present courts of law can be found in the book of 1 Kings, chapter 3. Each of two prostitutes had given birth to a son while they were living in the same house. One of the sons had died. Both women claimed the living child, and Solomon called for a sword and said, divide the living child in two, and give half to one and half to the other. The true mother of the living child cried out, O my Lord, give her the living child, and no wise slay it. Then King Solomon the wise said, give her the living child, and no wise slay it, she is the mother thereof. There can be no doubt that idealistically speaking, all of our judges should be more like Solomon, ruling in wisdom and the fear of God. However, if we were attempting to place the overwhelming majority of the federal judiciary in this country into one of the categories above, we'd be forced to conclude that they are much more like the evil prostitute than either Solomon or the natural mother. No one in our society is in a better position to restore the rule of law, and in so doing teach the proper application of law to all the people. But rather than receiving a lesson in law and justice when entering the arena of the courtroom, citizens receive lessons in craftiness, deceit, and sophistery, and obfuscation. Most of our federal judges have indeed become judicial prostitutes, and it would seem that they would rather than ruling justly would preside over the destruction of the republic in vain hopes of retaining some of their power. That cost me 10 days in jail. This was a editorial in St. Augustine Record. They always used to print my editorials, because I was always against government, so I always print everything I wrote. I had just had a big confrontation with a federal judge in Orlando, and I wrote this about him, and well, about all federal judges. I didn't name him specifically, but he read it. He was livid. He was livid. I get 10 days.
How did you get 10 days?
Oh, you were in front of him?
Contempt of court. That I defamed the court. And again, like I've been in jail 7 times for contempt of court.
Well, they deserve it.
There's no freedom of speech?
Well, no, not in court. And so in courtroom, I went to jail 7 times for contempt of court. Every time I went, I came back with 10, 12 more clients. To me, it was a marketing move. I didn't have to advertise. I went there and I got all kinds of clients. And if you like bologna, that's the worst they can do to you. And I love bologna. I was raised on it, so I love it.
Jail food.
Yeah, jail food, bologna sandwiches. I love them. And so, and there, I never mind it. And if you're not worried about that, every time I went back to court after he gave me it, they always treated me very courteously from then on. They knew I was not afraid of it, and I'd take it in a heartbeat. Wife used to ask me, "Are you coming home tonight?" I said, "I don't know." But I made it. I took a lemon and made a lemonade out of it, though. You know, I guess to get 10, 12 clients every time I went to jail. No advertising.
Gotta go to jail and get some more customers.
Okay, the law. This section is not intended to give the student the tools to fully understand the scope and nature of the laws under which the states and federal government operate. That goal takes years to achieve, and I doubt that any single source could make a significant contribution to that end. This section was intended as a wake-up call concerning the idiosyncrasies and complexities of the law, so when you come into contact with law, you're not immediately overwhelmed, and you have some understanding of the issues you may be facing. How would you define law? Most people have never really stopped to consider this question. For most Americans, law is something that the police officer uses to make an arrest or issue a traffic ticket. To others, it is a bunch of confusing books that lawyers use to bamboozle you out of what's rightfully yours. If you hold these opinions, you're right, but you're all barely scratched the surface. The law is any system or part of that system that creates or recognizes rights, duties, or obligations and provides a forum through which to seek a remedy in the event that any of those rights, duties, or obligations are breached. Although one would ordinarily think that in the course of history there have been many different forms of law, one would likely be surprised, if not downright shocked, to learn how many different forms of law exist in America at this very moment. Here are but a few styles of law that you may be called upon to operate within if you find yourself head-to-head with a legal system. Common law, equity law, admiralty maritime law, administrative law, private law, public law, constitutional law, treaty law, bankruptcy law, international law, state law, municipal law, federal law, family law, corporate law, probate law, contract law, tax law, civil law, criminal law, labor law. As you can see, things can get challenging rather quickly. Each form of law has its own special doctrines and standards. Many times one form of law nests within another. Unless one understands the idiosyncrasies of the type of law being used or applied in a certain case, one will often feel railroaded toward an unpleasant outcome. Although this class cannot possibly educate its students in every area of the law, it's our goal to make you aware of the broad concepts that govern the legal trade. After that, it is you who must do the work if you wish to better understand the Byzantine maze that is our legal system. Before you get into a legal battle with a private individual or the government, first send them a constructive notice of or implied notice of damage or injury they have caused. It is preferred evidence in court and complies with the UCC. If you do this, you are well on your way to winning the battle. Notice and demand. Elements. There is no penalty for making reasonable mistakes in good faith. However, if one intentionally does harm, then he may be sued. Nevertheless, before he can be sued, he must be given fair opportunity to correct his error. The notice gives one that fair opportunity. By it, he may have sufficient notice to assert proper diligence and inquire further as to discover that which an inquiry pursued in good faith would disclose.
No, that's what the IRS does when they send you the first letter. You know?
That's what you should have done also, that last letter that from that guy we read. And once you do this element, notice and demand, at that point there, that's preferred evidence in court. You're on your way to winning. There's a wide latitude in the style you use to write the notice. You can pretend you are writing to your sweet old grandmother or the devil himself, the IRS. From the court's point of view, the style doesn't matter if the legal points are made. Choice of style is a strategy decision. What effect do you want to have on the offender? Before sending the notice, remember to apply Mark Twain's 7 rules of good writing. Revise, 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 revise. It takes 7 major revisions to do a notice correctly. If you notice to your adversary, make the following points. Number 1, what is he doing or not doing? 2, your injuries, the loss of substantive rights. Notice injury and damages are not synonymous words. Injury is the harm done. Damages are the compensation for the injury. 3, his duty not to cause you injury. The moral, public, and private laws that require him to not cause your injury. 10 Commandments, Bill of Rights, 18 U.S.C., etc., and your own rules. Number 4, he is breaching that duty. And state the damages, what he owes you for the injury. Cite the moral, public, and private measurements of the damages. Biblical, 18 U.S.C., 1985, 1986, 83, and your own estimate. Demand that he in good faith do his duty, pay you the damages, and do so within a reasonable number of days, usually 60 days for government and 30 days for everyone else. If he does not do as demanded within the allotted time, then by tacit procreation, assume power of attorney, you will determine for him the facts, his duties, and the damages he owes you.
Now, is that state government or federal government today?
That's for both.
Okay.
If he does not perform as demanded, you will take lawful action in personam and in rem to defend against him and persons acting in concert with him who cause an attempt to cause said injuries, to secure your substantive rights, and to redeem the damages owed to you. The constructive notice should be served upon the adversary in the same manner that one would serve summons in the lawsuit. A proof of service should be executed and held for use as necessary in a future lawsuit. Knowledge of facts which would naturally lead an honest and prudent person to make inquiry constitutes notice of everything which such inquiry pursued in good faith would disclose. In another sense, notice means information and advice or written warning in a more or less formal shape intended to appraise a person of some proceeding in which his interests are involved or informing him of some fact which it is his right to know and the duty of the notifying party to communicate. Actual notice has been defined as notice expressly and actually given and brought home to the party directly. The term actual notice, however, is generally given a wider meaning to it as embracing two classes, expressed and implied. The former includes all knowledge of a degree above that which depends upon collateral inference, which imposes upon the party the further duty of inquiry. The latter imputes knowledge of the party because he is shown to have conscious of having the means of knowledge. In this sense, actual notice is such notice as is positively proved to have been given to the party directly and personally, and as such he is presumed to have received personally because the evidence within his knowledge was sufficient to put him on inquiry. Now, these other things I won't continue to add them. These are all what notices are, and these are just definitions and also court cases that say it. We'll skip down here. If you are, this is page 67 top. If you are prosecuted, move for a bill of particulars as to the charges and authority, jurisdiction, etc. of the government. In the federal system, they normally cannot answer or provide you with the exact nature of the charges because they almost never have jurisdiction. Bill of particulars. The people, through their respective constitutions, granted authority to the Congress and state legislature to adjudicate only a few matters. Actions at law, actions in equity, and actions under the rule of necessity, military. Admiralty was remanded to the federal government. The states are supposed to not have any authority to legislate in this jurisdiction. There was a time when someone aggrieved of harm would file a tort at law, and the nature of the action governed the rules of the procedure. If there was a breach of contract, then this was an equity matter. If the aggrieved party could allege a tortious breach of contract, this matter was moved from the equity side of the court into the law side. This is because the people must have access to remedy at law if this type of action could give relief. If one were in the military, or if one were under territory under martial law, the court was a military court. If there was a breach of international contract, the matter was federal and heard under admiralty. The Congress nor the state legislature can vest a court with authority that has not been delegated to it by the people, by the Constitution of the state. They cannot create a new nature of action out of thin air. Later on, when the constitutions of the several states were amended to recognize and administrate corporations, a separate court was established, and the action was in the form nature of administrative. Human beings could not be brought into administrative courts, as the only matter at issue was a breach of corporate charter by an artificial person. Somewhere along the line, the announcement and the complaint of the nature of the action was lost. The attorneys all got together and decided that it would be much simpler for them if they were only one form of action. So today there is no disclosure of the nature of the action unless one demands to know the nature and cause of the accusation by using a demand for a bill of particulars. I've been quite successful in this procedure, even in states that have decided that a demand for a bill of particulars is a discretionary motion before the court. For example, in Pennsylvania, the demand for a bill of particulars used to be prior to arraignment, so that one had the opportunity to raise a meaningful defense against the elements of personal jurisdiction and venue, to include territorial jurisdiction as well as the nature of the action that used to be part of the subject matter jurisdiction. Within the past couple of decades, they moved it into discovery, which is after arraignment, so the ability for one to challenge the jurisdiction of the venue of the court was lost. This is because entering a plea accepts the jurisdiction. In this way, the only subject matter jurisdiction was challengeable. If they say this is a matter of law, my defense against this jurisdiction is whether or not there is a damaged party. They're not asked if this is an equity jurisdiction because equity is not a criminal type of action. If they say this is a matter of hustings, which is the true nature of action of all administrative law, my defense against this jurisdiction is that I'm not an artificial person, unless I am a federal citizen, but that's quite another matter entirely. Unless they can show from their records in the Secretary of State's office that I have chartered as such. If they say this is an admiralty matter, my defense against this jurisdiction is whether the offense was committed on federal territory over which the state has retained concurrent jurisdiction, though I still have not found out how the state exercises an admiralty jurisdiction in light of 28 U.S.C. 1333. If they say this is a military matter, my defense against this jurisdiction is that I am not a member of the military. I am, however, a member of the militia of one of the several states, but they do not operate as such anymore. And two, the nation is not under the martial law. Where is it? Given the fact that there are currently 14 notices from the President of a declaration of national emergency published in the Federal Register, we may very well be in a state of national martial law. The one from March 6, 1933 is still in effect today. However, they are not going to admit the nature of the action, as this will admit that they're one of jurisdiction on the record for all to see. So they move to dismiss the charges nearly every time. While we will never succeed at bringing down the current regime in this manner, at least other folks see what we are doing, and some decide along the way that they want to learn this procedure. I contend that if only 10% of the people enforce their right to know the nature and cause of the accusation, we can most certainly shut down the incessant stream of revenue being fleeced from the people by these administrative courts. As far as the compelling government interest doctrine, this is clearly a matter founded in the law martial rule. The military authority is in the process of returning control to the civil authorities, but has not yet completed the process. Now, we won't get into this real in depth, but in 1861, when Lincoln went to war with the states, there was a guy named Lieber up in Boston who was a real hotshot attorney. And he came down and he wrote what's called the Lieber Code, which was adopted by Lincoln to run the Civil War with. Well, they found it very convenient, which really it's really martial law. And so it continued on to this day. We were under the Lieber Code. We have since 1861. It's never been changed. Common law was kind of gone away with. This is what I always say in my demand for bill of particulars. I simply do not understand the nature and cause of the accusation with regard to the elements of personal jurisdiction, venue, and the nature of the action until the prosecutor properly alleges them. I am therefore unable to answer a plea to the charge until I have an opportunity to raise a meaningful defense against these elements. I cannot rebut an unstated presumption. The courts operate on silent judicial notice of presumption all the time. It is time for this to end. Fundamental forms of American law. In America, our laws are comprised of several fundamental levels. The first is constitutional law. No other law of any form is valid unless it comports with the applicable Constitution. A law that cannot find its basis in the applicable Constitution is an unconstitutional law and thus null and void. At the state level, the next operative form of law is common law. The government has done everything within its power to wipe common law from the face of American courtrooms, but the common law was, is, and always will be the proper form of law for the de jure state citizen. Some modern reviewers have stated that the common law is harsh. We might observe that it is unforgiving and inflexible when a person transgresses the rights of others. I'm not convinced that that makes the common law harsh, so much as it does strict. God's law is harsh. It's meant to be, so that people understand they must obey the law. Equity law. Equity law covers a broad scope of legal issues and is used extensively in today's courts. Equity is distinct from common law. Equity must always be voluntarily accepted, and there must be a contract nexus. In the federal system, jurisdiction always attaches by contract. What kinds of contract do you have with the federal government? Equity, a system of jurisprudence collateral to and in some respects independent of law. Black's 6th edition. Now, whenever you're getting dictionaries, I would suggest you get Black's 6th, 5th, 4th, anything besides 7th. 7th used for doorstop. Every time a person uses an effective argument, now, any dictionary that cites a word is only secondary authority anyway in court, not primary authority, like case law would be. But if you use something effectively and a jury buys it, and the definition of Black's has been used successfully in many instances in the United States, the description of the United States. So all of a sudden, the 7th edition doesn't have the description anymore of the United States. You can't find it in the 7th. So you start looking at these, so waters down the language, even though they're just as valid, all the old ones, the first is just as valid as the 7th, as far as legal language. So go back to the time period that the law was written and get that dictionary. Yes?
There's a book up there called 1984. In there, George Orwell mentions newspeak, where you shape the language so that ideas of liberty and freedom and personal responsibility cannot even be expressed. And that's how you take control of the culture. They've done that through textbook factories, and they're doing it through the law books and dictionaries, etc.
I've got 12 different dictionaries, law dictionaries from different time periods. And when I do constitutional research, I go and use Webster's 1868. That's the law at the time. So I use that language. The law as stated in that dictionary is what the framers used. That's their intention. The laws then, the words then, are not the same as they are today as far as description. If you look at a dictionary in the 7th versus 8 Black's 2nd, you won't find the same word probably. It'll be changed to the point it means nothing. Always go back to the time period the law was written and see what the language was at the time. Use that dictionary. Yes?
Is this, I simply don't understand the nature and cause of the accusation. Is that in letter format?
That'd be in motion format.
Motion format?
Yeah, you can do it verbally or oral motion, but you make a motion before the court for bill of particulars. I do it orally and give them a written motion. Yes?
That can also be done administratively, can it?
Yes.
Okay.
Yeah, this will shut down administrative hearings.
Right.
This will shut down traffic tickets. This will shut down a lot of stuff because they've got to show you if you're subject to it, and they can't.
No?
Yes.
In this, where you quote yourself, you don't actually use the term bill of particulars.
Yeah, I should.
Should you?
Yeah.
Okay, so add that on there.
Yeah.
So if you had like a property inspector that came onto your property, would you start off with where he's just telling you gotta do something, would you start off with the bill of particulars, or how would you?
No, property is something different. I was up in Eagle River, Wisconsin, and this property lawyer was the one who sponsored the meeting. He had it in his office, and he was not doing very well because he had a whole week and nobody ever came in, and he was dying because the regulations of the Department of Natural Resources kept giving him regulations that had the effect of shutting down people's property. You can't use your lake anymore or put a boat ramp because there's a dangerous frog species living there. And so they were damaging people's property like crazy. And he, as a lawyer, he tried to fight it and didn't go anywhere. And I told him, I said, there's a concept of law called inverse condemnation, where if they, by legislation or type of activity or regulation, they diminish your property value, then you have a right to have that diminished value replaced under the Fifth Amendment. They have to pay you for it. So if you use inverse condemnation as your argument and you challenge and you sue them in court, in federal court, at that point there, they must. And so he started doing that. And all of a sudden, he started winning. They just kept dropping regulations like right and left. Now he's the most sought after property lawyer. Now he's charging $400 an hour. Before he was starving to death. And now he's winning these cases. He just files a lawsuit. They drop the regulation. They change it. Because they know that they're damaged to you. They don't want to pay you for the damages. So they drop the regulation. You have a bunch of bureaucrats out there making laws that they're not accountable to anybody. They're appointed. They're not elected, but they make these rules all the time, and you have to live by them, and you lose your property value because of these rules. These tree huggers are famous for that.
Wouldn't there be a way administratively, without going all the way to court? Let's say a property inspector comes onto your property and says you've got a, let's say weed abatement, or they want you to move junk.
File a bill of particulars. File a bill of particulars. File a bill of particulars. Let them come up, and you can't answer the charge unless you know what you're being charged with. Show your venue, show your subject matter jurisdiction, show all these things to me, and then I'll make my defense.
What's the crime? What's the violation?
Yeah.
Right.
Instead of them just telling do this.
And where's the foundation in the Constitution?
Why?
Where's the foundational support for it, the authority?
This is something that Orlin brought up, but we hear it a lot over the phone. The state or the county or the city will come over, and they'll actually walk right onto somebody's property, take pictures, come back and say, clean up your junk, or we'll fine you $100 or $1,000 a day, kind of thing. It just seems to be like all of a sudden it's popping up and it's endemic everywhere.
It is.
Is there some scam that's going on behind that?
Well, I think it's
money.
I was down in,
Yeah.
we went to California, Ralph and I were in California not too long ago, and these people are being charged $300 or $400 a day for violations that these guys dream up. They make them tear their houses down because they don't comply with the law that was passed 4 years after they had made the changes. They go back and retroactively try and have them tear their house down. It's happening all over the country. This is something that's not new. It's happening everywhere.
We were just cited for a patio that was built in 1988, and they want us, it was turned into a deck in 1988, but they want us to tear it down now, because, they decide now that they don't like it right.
And there's something in the law that the Constitution says no ex post facto law. Well, that means they can't come and make a law retroactive. And they can't do that. That's against the Constitution. That's what you assume. The rule in court is that if plaintiffs win, defendants lose. That's the general rule,
Right.
because plaintiffs' allegations are all deemed true until rebutted. And so if you go as a defendant, you're probably going to lose. Go as the plaintiff in the action, you're probably going to win if you followed your proper procedure. What makes the difference between winning and losing as plaintiff is you know the rules of court and civil procedure. If you don't know the rules, you're not going to win. I guarantee you that. There's 86 rules in federal court and 234 sub-rules. If you know only half of the rules, you'll win. More than lawyers, because most lawyers have become lazy because the judges don't require them to know them. They're good friends with the judge, and how was your golf game? Fine. They don't worry about the rules. As soon as a plaintiff goes in there with an action, without a lawyer, and you walk in there and you assert Rule 13, and you say, well, Your Honor, he's in violation of Rule 13. I'm asking for sanctions against this attorney. Pretty soon you wake them up. They're going to a gunfight with a knife because they're not prepared for you. They're not used to that. Yes?
You were just saying they're all friends. Kath and I had an experience of this when we did our bankruptcy. What I always do is I just start calling everybody in the phone book. So I called every lawyer between Grants Pass and Wairika trying to find somebody, and coast to border, and just calling everywhere. And this one fellow's name kept coming up and coming up and coming up and coming up. So finally we went to see him. And during the course of the interviews with him, we got to know him. And then we were getting close to the bankruptcy day, and I said, Jim, tell me how this really works. What's really going on here? He says, well, he said, the bankruptcy trustee and I are good friends. He and I play golf together, just like he said, and we know each other. By the way, his wife and I are both rose collectors. We know each other. He says, when I go into court, he says, you watch what happened. We'll go through the formalities of calling the case, and I'll speak it out. And he says, at one point, he'll look at me and he'll go like this, and then I'll go like this, or I'll go like this. If I go like this, that means go ahead and do it. There's no problem here. You won't get in trouble with this one. If I go like this, that means take this one over the coals a couple of times. Just exactly what he said. We sat down in the courtroom, the whole sing-songy thing, and then he went like this, and the guy said, approved. Kath and I walked out, what is it, 10 minutes at the most? Just in and out.
The legal system, you're
Voices.
looking for justice, go to church. You won't find it anywhere else in church. You won't find it in court. It doesn't exist there. It never has. When I was a cop, one judge became very friendly with me. He was going to run for, if Romney had been nominated or elected president, he would have been a federal judge and I would have been a federal marshal. That's how friendly I was with him. And he used to ride with me on Saturday nights. He'd come in and sit down and big old pistol in his belt and suit, and he'd ride around my squad car at night. He loved the action of the cop. He loved it. And so one night I stopped a guy for speeding, drunken driving, something like that, and the judge was going to hear the case. And so anyway, I used to go 15 minutes before court. I'd go into his chambers and we'd talk about friendly stuff. Hey, what you doing, Judge? And he'd say, what you got today, Mel? I'd tell him all the cases I had. He said, well, first one, what do you want done? I'd say, give him 10 days. Give him a $100 fine. Do it. I told the judge, he'd write down everything I said. He'd go out there and boom, 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 boom. That's what happened. My wife was, I was chief of police, and my wife was speeding past me. I was showing a new patrolman his routes, and she went flying past me. And he said, isn't that your wife? I said, yeah, it is. So I was embarrassed, so I put my loudspeaker on and said, pull the car over. I put my siren light on, and she pulled over, and I walked up and said, give me your license. She looked at me, gave me your license. I went back and wrote her a ticket. And I gave it to her, gave her a court date, and I went to court and I said, now it's going to cost me $25, but it's worth it. But scare her. Were you scared that beat Jesus that? Because she goes too fast, she's going to kill herself. He said, okay, don't worry about it. So he went before, and that's the best $25 I ever spent, because he reeled in her for about an hour. He said, young lady, you come back here, I'll put you under the jail. Well, for 6 months, I had nothing from her whatsoever. But I got my $25 worth, But that's again, that stuff happens all the time. The police officers are so close to the judges, and so are the lawyers that practice there every day. These trial lawyers who practice there every day. It's a done deal before you go there. So when you go there, make sure that there's a surprise coming to them that they recognize. Bill of Particulars is one of the surprises. And especially traffic court, you go and challenge jurisdiction there. The guy doesn't know where the bathroom's at, the prosecutor, because he's probably the lowest graduating of the law school. He's got the job because he can't find a job anywhere else. He's either that or construction. He's a prosecutor in traffic tickets. He goes there and he cannot answer a jurisdictional challenge if you gave it to him. So that's where you challenge the jurisdiction. Yes.
When you walk in with the traffic secretary to the traffic court, you hand them a motion?
If you walk in, you've already lost.
Right. Okay.
We'll get into that later on.
I was going to say, because I was standing before the judge and I handed him a motion. It's on there under special appearance, and he goes, denied, didn't even open it.
Just by appearance, you waived all defects of process.
Denied.
That's the rule.
Right.
And if you waive defects of process, you're theirs. So she had it's called abatements.
I ended up disqualifying him under 170.1 and 3.
Yeah.
And they sent it. I had the whole thing transferred out of the county down to San Diego, and he did all kinds of things. And I filed a 70-count criminal complaint. Some of them were felonies. Get one judge, one district attorney, nobody could pick it even up and look at it.
Be careful some of that stuff, because you start doing that kind of stuff, you can be prosecuted yourself.
Well, about 10 years ago, and I haven't done it since.
Yeah, some people are going to prison now for that, because they're filing malicious actions and against judges, and they're being taken to court and criminally prosecuted and going to prison. Be careful about that stuff. A lot of paid community stuff has been done for years. They're getting fed up with it. I'll tell you a little thing, but we'll go on again. This Professor Chopin from University of Miami Law School. I sent an invitation out to a lot of professors and a lot of people. I got an invitation to go to this class, something about probate, something that nobody would ever go to. But in a little comment, this is not probate, this is what it's called, but that's to hide the true meaning. This is trying to stop the patriot filings. And I've invited all court clerks and law professors to come down and hear this. So I paid $500 and we got a big book like this of all the different documents that these patriot groups were filing. I had the Eddie Kane stuff. I had the Kowalik stuff. I had all the different patriot group stuff, and the militiamen up in Montana. I had all of their stuff and all the different filings that they have. And they were saying, this is from the Montana militia. Notice that every third sentence is bolded. It makes them feel good to bold things. And so from now, if you see any bolding on any document, don't file it. It's a patriot argument. Don't file it. When you file something in legal records, it gives more legal sufficiency the longer it's there. So if you file something there and it stays there for a long time, it has more legal sufficiency and goes to trial as evidence. So they don't want these things filed. So they had all these different things. And I had a whole list of stuff. And I was there as an agent provocateur. I wanted to see what they were trying to keep us from doing so I could tell my students, don't do these things and get them filed. I always found when you file a document in courthouse, they don't accept a lot of stuff. But wait about 4:45. And you look at see who the laziest person there. Usually it's Bertha. Bertha's got 6 kids at home. She wants to get home, cook supper for the old man and the kids. And she wants to get the hell out of there. And she's busy cleaning up 15 minutes before time. That same woman, 8 o'clock in the morning, hates her job, hates being there, and hates you for bringing something in to make her work. So if you file something early in the day, she'll reject it. If you file it at 3:45, she'll file a garbage can lid if you give it to her, because she wants to get the hell out of there. So always wait until last. Look for the laziest person. That's who you file them with. Now, if you have trouble filing something, give it to a lawyer. Give them $50 to file it for you. They'll take anything a lawyer gives them and file it. So there's ways to get things filed if you want them recorded.
Really?
Yeah.
Yeah, that's a good.
You said with the court. How about with the county recorder? Same
Yeah, that's the same thing. The county recorder. That's what I'm talking about. Yeah.
What if you bury something under a trust deed or under a deed? So.
No. No, don't try and just file it normally. I file all kind of documents all the time. I've never had a problem ever getting it filed. These patriots who want to do loyal title, they walk in, I'm going to file my loyal title here, and you can't ever file no taxes no more. I'm not paying no taxes, no damn taxes. I got loyal title, King's title. File this for me. They do it all the time. And I see this patriot do this stuff. They're stupid in what they're doing, and they're ignorant, dumb people. And that's why they don't win. They blame it on the court system, they blame it on the clerks and all these other people, and they're the worst enemies. They're the ones doing everything wrong. You've got to follow the rules of court civil procedure. You've got to follow the rules that they have in the courthouse. They have these rules. They're long accepted. Follow them. You can do the same thing, just do it right. Don't bold every sentence. It makes you feel good. You bold it. Oh, I showed them, boy. I feel better about that. But you just identified yourself as being an idiot, you know, because lawyers don't bold anything. We're lazy. We don't do any extra work we don't have to. You know, we never bold stuff.
Another thing too is filing it as though someone would read it.
Yeah.
Like the bold is nobody's gonna.
Let me tell you about this one idiot who was working with PQI, Dark Cloud. They call him Dark Cloud. He wears everything black. He asked me, he was going to file habeas corpus for a lady who was having some problems. She was convicted, and he went to file habeas corpus to get her out. And he was going to file it in Washington, D.C., and he never filed habeas corpus before. And he said, do you have one I can copy from? So I sent him a habeas corpus. I said, now you're going to change this around, modify it, but this is what they look like, and this is some of the same content and material that you'll be using. And mine was about 26 pages long, I think. Well, he finally finished one, emailed it to me. It took me about like 2 hours to download it off the computer. It was 128 pages. 128 pages. It was like this. And I said, number one, do you think he's going to read that? And number one, the judge never read it. The clerks always read it. The judges don't read that crap. They have a staff of clerks that work for them. These clerks, I was a clerk at one time. I know exactly what the judge gives them. Here's, please go read this stuff. Tell me, give me a summary on it. The clerks are the one to read it. And so if I get this to read like this, it goes right to the garbage can. I read the other guys, I give a summary, the other guy won, automatically. I never read that crap. Nobody does. So don't waste your time. Don't tell them everything that you know. Save that for trial. Tell them the bare necessities of what you have to know to get in there. Save the other arguments for court, for trial, for jury.
And stay on point.
And stay on point. Yeah, don't wander. These people are all over the place. Yes?
Now, we do filings here, filing sovereignty declarations, things like that. Going down to the local county courthouse, 2 years ago, I had no problem. They simply accepted it, filed it, no problem. Several other of our clients have attempted the same thing since, and they're no longer filing this paperwork. Okay? Other than going to a lawyer, what would you suggest at that point?
Go to a lawyer and just make a deal with him. to Eddie Kane had a lawyer down there in his staff to use his signature, and he had a rubber stamp with a signature on it. And every letter Eddie wrote, with the lawyer's letterhead, he'd stamp this guy's name, and the lawyer got $5 for every letter he sent out. He was making $300-400 a day because Eddie had a lot of clients. He loved that income. Well, I had written a letter for Eddie about the Attorney General, Inspector General for under the new tax law that went into. You can file a complaint against IRS agents. And I wrote a letter for him. I said, now use this judiciously. Don't use it because it's going to cause a lot of trouble if you just give it to everybody. Just use it in really extreme cases. Well, knowing Eddie, he sent out to everybody. Everybody got one. There was like 4,000 people, complaints to the Attorney General, the tax division. And he called up the lawyer and says, what is this? The guy said, what do you mean? He's like, I got all these 400 letters up here, 4,000 letters. You filed these complaints. I only got 4 people working for me. What am I supposed to do? And he said, what letter? He said, this letter from your office. Well, just a minute. I'm real busy. Can I call you back? He called the lady and says, what the hell is he talking about? What letter? Oh, I sent a letter out under your letterhead. We're asking for investigation of these agents, and this is what he said. Fax me over a copy of the letter. He sent it to him. He said, don't ever use my name on that again, ever, because it really got the dander up in the federal government. Now Eddie Kane's no longer in business. He's in Panama, I think. Yeah, he went to Panama. And unfortunately, he's got 4,000 people following him. There's nobody to follow anymore. They closed him down. So these people come and go. Be careful who you're dealing with and what you do, because everything you send out on your signature, they don't go to jail for. You do. So make sure what you're reading is accurate and to point. Don't just start signing your name to documents.
Just as a follow-up, again, what this county clerk said in Medford is, we haven't filed paperwork like that in 10 years. Again, I did it 2 years ago. Is there any reciprocation against the clerk? Is there anything we can do?
Isn't she breaking the law by not filing?
No, don't start getting those kind of. You'll lose those kind of contests. They're trying to do the job as they're told to.
Sure.
Now, the chief clerk is the one who would have responsibility, but he is required to file certain documents by statute. So you go back to the statutes and see what documents he's required to file.
We have that.
Now, if they fall within that category, he's required to. If at that point there, if he doesn't file them, then you sue him for a malfeasance of office.
But the statutes are different than, say, the job description.
Well, the statute governs.
Right. But what I'm saying is that the statute itself, the county clerk's job description, as presented to them when they got the job, doesn't necessarily reflect the statute.
Well, again, you would sue them, and again, if that's the case, then the judge would say, okay, from now on, you tell the county commissioners to rewrite his job description to comply with the law.
The county clerk is obligated to understand
The statutes that he operates under.
His activity or her activity.
Yeah.
In Deschutes County, I had this conversation. She was quite aware of the statutes. In fact, I said, because I didn't have it with me, she mentioned, I said, oh, can you write that down for me? And she said, sure. And she, on a piece of paper, she wrote down ORS, certain, and I went home and jumped on the computer and I printed, and it says, one of the specific phrase you're looking for is and other documents.
And other documents.
Right?
How about I don't give you permission to make a legal determination for me? And if you think you're representing me, you're fired.
Well, yeah, so the concept is there now that it says and other documents, and I have this, and I also got her to give me a copy of her oath of office. So she's got an oath of office, and I haven't gone back yet. But the concept is to go back, file again with the witness.
I would file an action against her, civil action against her for malfeasance of office.
Right.
And
the step that he's going to take first is to go back and say, is this your signature?
Yep.
Yes, it is. This is your oath of office? Yes. You see here where it says to file documents? Yes. And other documents? Yes. Here's some other documents. Please file them.
Yep.
If she refuses, then you go down.
I'm going to take 2 witnesses with me as well. And then if she still refuses, I could put her on verbal notice at the time. I might even bring a notice with me.
I'd send a notice of demand. If she's damaged you. If she's damaged you.
We have another strategy, Mark. You want to bring that forward? What was that called? The strategy?
Notarial protest?
No, where you go down after the oath of office and you go to who about her bond?
You go to the complaint office in the county office. You go to and say, I've approached the county clerk. I'd like to file a complaint against this government worker.
Yeah.
Three complaints. They lose their bond and lose their job.
And they're fired.
I don't know if I want to do that, though. I just take them to courts. Get the thing changed.
Yeah.
Be the action. Take it
Take
to
him to
court.
court, and the judge is going to side with her. He's going to dismiss
here's
it.
what we found.
Not necessarily.
Now what we found is that you go down and you do the first one, and you come back the second time, you walk right back up and you say, I'm here to file these papers. I thought we just went through this. I'd like you to know that I filed a complaint against you because you didn't follow your oath of office. If you refuse me again, I'll file a second complaint and then I'll be back here to do a third. If you refuse the third time, I will take your job. Wait a second. They go back, they talk to the supervisor, they huddle in the back room for a little while, they come out and file your
No,
papers.
that's not what happened in Medford.
Not in Medford. What happened in Medford?
They filed the 2 complaints, and on the presentment of the second complaint, the county clerk said, you step into this office again, I'm calling the sheriff. He said, great, let's have a meeting. He actually went down to the sheriff's office and talked to the sheriff, and he goes, yeah, I know exactly what you're trying to do here, I understand, but they're just not following this kind of paperwork. Well, what's going to happen when I go in there, and now she calls you to arrest me for approaching her again to file this paperwork? Never went that far. The client backed off and hasn't done anything since. So that's where it stands.
Sue.
I guess that's when you'd
I've never had trouble. I've never had trouble filing paperwork because I make sure that it looks exactly like the other paperwork. If I'm going to do a declaration of land patent, I will make sure the quitclaim deed looks exactly like every other quitclaim deed in the world. The only difference is there'll be a few words changed that are different than the ones they're normally seen. Since they don't read the entire thing, it's there in plain sight. And I always have a box of Krispy Kremes with me, and I give them to them.
Too many days with the police department.
They can't resist Krispy Kremes. And
Dunkin's doesn't work.
so I never had trouble getting filed. I'm always polite, very polite with them. My fact is, I remember Valentine's Day. I make sure I drop my candy for them. I do all those things. And I never had trouble getting anything filed. And I filed some ridiculous stuff. Not garbage can lists, but close. But don't be antagonistic if you don't have to. Try and be as polite as you can. And try and bribe them with Krispy Kremes. It works for me. Okay, let's get back to this. Equity jurisdiction. That portion of remedial justice was exclusively administered by courts of equity as distinguished from courts of common law. Here's a fascinating definition from Bouvier's Law Dictionary of 1856. Equity, court of. A court of equity is one which administers justice where there are no legal rights. The most succinct, although not exhaustive, definition of equity would be this. The term equity denotes the spirit and habit of fairness, justice, and right dealing, which would regulate the intercourse of men with men. It's important to note that whenever the word fair is involved, it means that a third party will decide what is fair for you. Despite the lofty ideals of equity, what is thought to be fair in the mind of one person may often be thought to be completely unfair in the mind of another. If the common law is competent to provide a remedy, one need not acquiesce to the jurisdiction of a court of equity. This is where the statements to suitors clause comes in to save the day for us plain folk. Next would come statutory law. This is the form of law that most Americans know as the law, although it is a form of law with extremely limited power. Statutory law is comprised solely of the acts of the legislature that become law and are currently in force. Most of these legislative acts, statutes, have been codified into one title or another with a set of codes. There are a couple of significant points to remember. First, most codes are not law, but are merely indicative of the law, prima facie. The law is the actual statute, the positive law that was passed by the legislature. It's conceivable that a statute could have been repealed, yet the code section still exists. If you're in a legal fight, always check the statute behind the code section. Second, keep in mind that not every single statute passed into law is codified. Some statutes simply stand alone and remain non-codified, hence the name statute at large. When searching out what the law says, always look to the annotated version of the statutes. This is what the Supreme Court has said the law is. Here's a real kicker concerning statutory law. A statute is an enactment by a legislative body bringing into existence its creatures, its corporations, and setting forth the privileges and immunities and responsibilities of each creation. A statute applies only to the rightful subjects of legislation, i.e. the creatures created by statutory fiat. The phrase rightful subjects of legislation does not mean the people unless the statute specifically states its intent to apply to private citizens. Do you have a license? Is your name spelled in all capital letters on your credit cards and driver's license? You have a ton of contracts out there that makes you a person wearing a mask which is subject to the legislation written to control it, and you have to get rid of them. Of course, once you remember that one could create an obligation to a law that would not otherwise bind him by involving himself in various regulated activities, by entering into or an agreement with the government, such as requiring a business license, resale permit, etc. Now, one thing about the law, whenever you read the law, if you went to any lawyer and you say, would you please read this law to me, and maybe it's one paragraph, and let me know what it says, he'll say, okay, I'll get back to you next Wednesday. I'm really busy now. He'll sit down and he'll take that sentence apart, word by word. He'll go back and check the original intent of the legislatures that they wrote it in. When he finishes, he'll look at the annotated, if it's been ruled on by appellate court or the Supreme Court. He'll look at the annotated version of what the law says. Then he'll come back and tell you what the law says after doing all that work. He won't just read it like you would, one paragraph. We think that if we read a paragraph, it means what it says. It doesn't. Example, in Michigan, there's an actual case in Michigan where a guy went, to the Department of Natural Resources to get a killing license. He walked in and said, I'd like to buy a killing license, please. He says, we don't sell killing license, we sell hunting license. He says, no, I don't have to hunt it, I know where it's at. I want to kill it. The guy said, well, we don't have any killing license, all we have is hunting license. He said, well, I want a killing license. He said, well, I don't have any. He said, well, I'll go kill it then. He said, if you do, I'll have to arrest you. He said, well, you have to do what you have to do. So he took off with his son in his pickup truck, drove down to his property. There was a moose there, and it was in his back 40, and he shot and killed it and put it in the truck. And on the way back to town, sure enough, he was arrested for hunting without a license. They took the moose, put it in cold storage, took him to court for arraignment. He said, Your Honor, I went down to the Department of Natural Resources and asked them for a killing license. They said they didn't have one. They said, I want a hunting license. I said, no, I don't want to hunt it. I know where it's at. And I told him that specifically. He said, well, I don't have a killing license. I only have his hunting license. He said, well, fine, I'm going to kill it. And I went and killed it and put it in my truck. And the judge asked the warden, he says, did he in fact come down and apply for a killing license? Yes, he did, Your Honor. Don't you sell killing license? No, we don't, Your Honor. We only sell hunting license. He said, case dismissed. The statute says hunting without a license. He wasn't hunting it. So don't read something into the law that's not there. Every word has a meaning. Otherwise, they don't throw words there to be superfluous. They mean something. So law means every word is exacting. They choose their words very carefully in writing law. Don't read something that's not there.
Judge, my luck, they'd
Change your luck.
Okay, other important distinctions, classifications. Every law that defines an offense falls into one of two categories. The first category is mal in se, and the second is mala prohibita. A mal in se offense is a crime that is by the laws of nature and God a true crime. Examples of this would be murder, rape, robbery, etc. Mala prohibita offense is one that would not be an offense were it not for the legislature passing a law that makes a particular act a punishable offense. Example of this would be possessing or smoking marijuana, buying and selling more than 7 cars a year without a dealer's license, not obeying road signs and speed limits, etc. Application. Various laws also apply to certain groups of persons and not to persons outside that group of persons. For example, if this was laws concerning licensed contractors, the state has no blanket authority to require every person who for profit plumbs or installs a lighting fixture or builds a patio deck to apply for and acquire a license. Here's a list of the persons who must have a contractor's license. 1, any person conducting certain defined types of construction on state property. And 2, any person who has entered into a contract with the state to perform certain defined types of construction. And 3, any person who has acquired a contractor's license and has not properly canceled it. And 4, any foreign corporation doing business in your state. Nature. All legal actions fall within one of 2 broad categories, civil or criminal. The penal code of each state is the code from which crimes are prosecuted. In California, as in most states, the Code of Civil Procedure states at Section 31, the penal code defines and provides for the prosecution of a criminal action. Please note that there is no criminal action that is prosecuted from any other code. Civil action arises out of either an obligation or an injury. Here's how the California Code of Civil Procedure defined those 2 terms. Section 26, an obligation is a legal duty by which one person is bound to do or not to do a certain thing and arises from 1, contract, or 2, operation of law. An injury is defined thusly at Section 27. Injury is of 2 kinds, to a person and to property. An injury is fairly self-evident, as is an obligation connected with a contract. However, the obligation that arises from the operation of law may seem less clear. Operation of law. This term expresses the manner in which rights and sometimes liabilities devolve from a person by the application to the particular transaction of the established rule of law without the act or cooperation of the party himself. Black's Dictionary, 6th edition. In other words, an operation of law is simply some event or circumstance that lays a right or liability upon a person through no action of his own, and that right or liability must justify a civil court action. How federal law differs from state law. Federal law only defines mal in se crimes that occur within the federal places. In other words, federal law cannot define murder as such terms may be used within Florida. That's because the federal government may only define a mal in se crime for use within places that are under the exclusive legislative jurisdiction of the Congress. Compared to a state penal code, there are relatively few mal in se crimes defined in the United States equivalent of penal code at Title 18 U.S.C. or United States Code. Most crimes that are contained within 18 U.S.C. are actually regulatory in nature, mala prohibita. When dealing with federal law, the trick is to determine through research what is the exact nature and authority of the law being examined it will fall into one of three categories. A true criminal statute, and Mullins say, that applies to persons and property located within the geographic United States, i.e. Washington, D.C., or other federal lands, U.S. possessions and territories, and to a regulatory law, Mullins prohibited, that applies to persons and property located within the geographic United States, i.e. Washington, D.C., or other federal lands, U.S. possessions and territories, and to those who have entered into a licensed activity under the authority of the United States. A regulatory law, Mullins prohibited, that applies to persons and property located within the states of the Union under the enumerated powers of the federal government, which are expressly defined in the U.S. Constitution. Federal admiralty jurisdiction. The federal government frequently moves in the admiralty jurisdiction. The term used and preferred by the government more recently is a special maritime jurisdiction. They are the same snake with two heads. Admiralty jurisdiction deals primarily, or maybe I should say originally, with ships and occurrences upon the water. This special jurisdiction was a result of the issues of international shipping, questions of ownership over ships and their cargo, prize issues, defeating a ship at sea in battle, piracy, controversies over ship goods or when the owners are not in America, and salvage of vessels and goods, and various customs issues. When our nation was first founded, admiralty jurisdiction was restricted by the rule of tides. Under this rule, admiralty jurisdiction could only be invoked if the circumstance took place on the water or at the dock, subject to the natural forces of the tides. However, over the time, that yardstick was thrown aside, and admiralty reach was expanded by court decisions to embrace all actions previously cognizable under our admiralty, but which took place on any navigable waterway under the jurisdiction of the United States. In other words, if it's a navigable waterway that is in the United States federal territory, or if the waterway is used for interstate commerce, certain controversies that arise in such circumstances can be heard in admiralty jurisdiction. Yes?
I was reading an article about the Social Security Administration, and I was told and shown a picture in that article that the Social Security Administration building in Scranton, Pennsylvania, where they store your contract, your original contract, is a masonry building. I believe it's 5 stories, and it has a high water mark tide line around the top of it, so that all of the contracts held under that are under admiralty. More Patriot.
I've heard that too.
Yeah. It's patriot mythology. It sounds intellectually stimulating, but it has no really legal basis or fact. And one of the things about this class is sometimes I'll burst your patriot bubbles, and I want to do that because they need to be busted. I've seen too many patriots go to jail for using these arguments when they're absolutely baseless. The admiralty jurisdiction has taken over this country, has since 1861. It used to be common law in certain issues in the federal government until Erie v. Thompson case in 1938. So the federal court said at that point there, at the request of Roosevelt, that we got to get rid of common law on the federal level. And so that case is what they used. And they said, from now on there will be no more common law at the federal level. We will use, however, state common law in any action that's brought to us. And that's how it's been ever since 1938. So there really has been no body of common law excepting where they have enumerated power. Now, areas of interstate commerce, they have common law there. They have a lot of cases and stuff like that where they have enumerated power. But when they don't have enumerated power, they have no common law at the federal system. It's all admiralty equity. It's mostly equity and some admiralty. And whenever the IRS they always seize property under admiralty law when they seize property. And so the federal system is equity, admiralty, and maritime causes, and that's all. There's no common law federal system. Now, if you're charged with an offense, you want to do a bill of particulars, and then you want to invoke the savings of suitors to get out of admiralty into the common law. And usually they'll dismiss the case before that happens because they can't do that. Judge can put another hat on and use state law and be the judge for the state, be paid twice for his job. Once for a federal judge and once for the state, they'll pay him for doing it. They like that if you invoke it. They like to be paid twice. But the average person doesn't have a clue how to do it. Now, we're going to give you a supplemental disc. On the supplemental disc, we have how I invoke it, the language I use to invoke it. So you have a lot of stuff that's going to be given to you on the supplemental disc that we can't put in the book. It would be a telephone book. So make sure you take a look at this stuff and start studying all of it. You're going to probably spend the next 6 months of your life studying this stuff.
Is this it?
Yes.
It'll be a what kind of book?
Telephone.
It'll be big, too big.
It'll be a telephone book. It's a lot of stuff, a lot of material.
Well, as it is now, it's bigger than the Ashland telephone.
It'd be Title 26.
Okay, where did I leave off at? When our nation was founded?
Okay.
Okay, when our nation was founded, admiralty jurisdiction was restricted by the rule of tides. Under this rule, admiralty jurisdiction could be only invoked if the circumstance took place on the water or at the dock, subject to the natural forces of the tide. However, over time, that yardstick was thrown aside. And Admiralty's reach has expanded by court decisions to embrace all actions previously cognizable under Admiralty, but which took place on a navigable waterway under the jurisdiction of the United States. In other words, if it's a navigable waterway that is United States federal territory, if the waterway is used for interstate commerce, certain controversies that arise in such circumstances can be heard in Admiralty jurisdiction. It should be noted that the states of the Union also have Admiralty jurisdiction when dealing with issues of interstate commerce and when a state is acting as an agent under agreement with the Secretary of Transportation for the federal government in the enforcement of interstate commerce regulations associated with navigable waterways. It is widely theorized by tax law researchers that the IRS seizures were all made under Admiralty jurisdiction derived from alleged violation of the customs regulation in the Virgin Islands. The government is currently disputing this argument by stating that federal court actions involving seizures are commenced under Title 28 U.S.C., Federal Code of Civil Procedure. Guess what? Title 28 U.S.C. are rules of Admiralty equity. The Federal Code of Civil Procedure controls many but not all procedural aspects of Admiralty actions. There are common laws, rules sprinkled among the rules, but require research to find them. Civil codes with criminal penalties. Having discussed the difference between civil actions and criminal actions, one might wonder why some offenses contain a civil, non-penal code can result in consequences usually thought to be exclusively for criminal acts, such as going to jail. In most states, there are two doctrines that seem to be, at first glance, to be in conflict with one another. One item of controlling case law states that if you are engaged in an activity that is cognizable under the authority of one of the various civil codes, these codes can include penalties that are in the nature of criminal penalties. While the courts were not specific as to when such criminal penalties attach to a civil offense, we can only conclude that they are limited to cases that are regulated through a license or a contract. It's only under such a circumstance that a defendant made a prior agreement to abide by the conditions of the code and is therefore presumed to know that criminal penalties are part of that agreement. In short, the court appears to be saying, if you don't like the water, stay out of the pool. In the second case, an appeals court struck down a jail time portion of a sentence handed down to a former Los Angeles County supervisor who had been convicted on the misuse of campaign funds. In its decision, the court stated that the offense was civil in nature and therefore the maximum sentence that could be imposed was a fine, not jail time. This would appear to be a regulatory violation that was not supported by any form of license or prior agreement, and therefore the defendant had never agreed to allow criminal penalties to be applied to him for a civil offense. The metamorphosis of the law. Laws do not actually metamorphize, but their language is altered over time to obscure the true purpose and intent of the law. One would think that once a law is passed, it would not need to be altered unless some shortcoming becomes apparent, or some circumstance changes that requires that statute to keep up with the times. I think the average citizen will be surprised to learn that statutes are amended to alter the language for no apparent reason. I stress the word apparent because the legislative draftsmen who propose these changes know exactly what is their purpose. In the following fictitious example, we are going to provide you with the year that a statute was passed, as well as the text. I will then give you the year of each amendment of the statute that changes the prior language. After reviewing the progression of the changes, look again at the original version and take note of all the clarity that has been lost. You will see how the changes have rendered it impossible for a person to know what was the intent of the original law. This practice is more the rule than the exception for the Congress and the state legislatures. 1959. It shall be illegal for any foreign corporation to produce widgets except between the hours of 8 a.m. and 5 p.m., Monday through Friday. Widgets may not be sold without first having obtained a license in accordance with the Business and Professional Code, Section 12345. 1970. It shall be illegal for any corporation to produce widgets except between the hours of 8 a.m. and 5 p.m., Monday through Friday. Widgets may not be sold without having first obtained a license in accordance with the Business and Professional Code, Section 12345. 1973. No corporation shall produce or sell widgets except between the hours of 8 a.m. and 5 p.m., Monday through Friday. Widgets may not be sold without having first obtained a license in accordance with Business and Professions Code, Section 12345. 1979. No person shall produce or sell widgets except during the times allowed by law. Widgets may not be produced or sold without having first obtained a license in accordance with Business and Professions Code, Section 12345. 1990. No person shall produce or sell widgets except in accordance with regulations pertaining to this section. Widgets may not be produced or sold without having first obtained a license in accordance with Business and Professional Codes, Section 12345. 1994. No person shall produce or sell widgets without having first obtained a license. Now let's go back and read 1994 and the original 1959. 1959, it shall be illegal for any foreign corporation to produce widgets except between the hours of 8 a.m. and 5 p.m., Monday through Friday. Widgets may not be sold without having first obtained a license in accordance with Business and Professions Code, Section 12345. Now we go to 1990, 94. No person shall produce or sell widgets without having first obtained a license. What is important for the reader to understand is that the intended meaning of the application of the law, as indicated by its original language, cannot be altered by amendment. The 1994 version still means the same exact thing as the 1959 version. If there are any questions as to the proper meaning of the application of a law, the prudent person will seek out the earliest possible version of the statute in order to confirm the issue. They do that, especially in the IRS code. You look at 1939 tax code, and you see it's, which is still valid, and you start seeing what it said, and go back today and see what it says, completely different. But the intent cannot be altered by amendment. The intent still remains. Now, most lawyers are too lazy to do that. It takes a lot of research to do that, and most lawyers do not take the time to do it. The ones that do charge you a fortune because it takes time. They deserve to be paid. And you probably don't want to pay that kind of, like you go to Larry Beecraft and Bernhoff, and these guys, they want $50,000, $75,000 retainers. They're worth every penny of it. If you look at 5 or 10 years in prison, just divide 75,000 by 5 and see what it is per year. If you make less than that, go to jail. If you make more than that, maybe stay out, pay it. Okay, the other law. There's a form of law that's not really law at all. It's commonly referred to as case law, also known as a decisional law or a precedent. Case law is a previous ruling on a point of law by a court of competent jurisdiction. Case law, when used properly, is intended to provide consistency concerning points of law over time. In theory, this allows a person to go into one court on a particular subject in the year 2005 and feel confident that the court will make the same ruling on a particular point of law that the neighboring court made in 2003. On the surface, who can complain? Unfortunately, that leaves the meaning and application of specific points of law to just about every Tom, Dick, and Harry who wears a black robe. We believe that today most practicing attorneys will admit that case law is becoming a quagmire of conflicting opinions that often lead to more confusion than clarity. There are two institutionalized problems with case law that need correction before this disaster called case law can be rectified. They're intricately connected. The first problem is the general unwillingness on the part of lawyers to challenge existing case law. There are three arguments that can be used to challenge case law. One, a view that the circumstances that led to the ruling on the point of law in the previous case are not substantially the same as are at the issue in the current case, and therefore the ruling on the point of law in the previous case is not controlling in the current case. Two, a view that circumstances that led to the ruling on the point of law in the previous case are the same as the current case, but the previous court simply ruled in error concerning the issue of law in question. And three, show that what happened but has been passing as for case law is actually nothing more than obiter dictum. Okay, option one, stated plainly. We'll get into that a little later, what that is. I call it bullshit or more bullshit. If you go to a bar at nighttime, talk to the bartender about your marital problems, he will give you all kind of dictum or obiter dictum, and that's what judges do. And we'll get into what that means later on. Okay, opinion one, option one. Stated plainly, most lawyers are just too lazy to tackle option number one. This sort of argument takes time and effort to put forth and is rarely seen except in high-dollar corporate legal battles. In most courtrooms, case law is never challenged, even when it's not terribly applicable. Option two is basically dead on arrival. Lawyers will almost never adhere to that one court decision of a previous court is just flat out wrong. Even on the rare occasions that an attorney is motivated enough to make the argument, the court is virtually never willing to overturn a fellow judge's ruling on a point of law. We get the impression that, like the aristocracy of old, today's judges consider it impolite to publicly declare another learned and honorable judge to be wrong. Option three would require an attorney to actually read the court's decision, and sometimes all the briefs, motions, and other filings from the very beginning of the case. Reading previously decided cases is very time-consuming and at times exceedingly boring. Neither of these are the kind of things in which attorneys like to involve themselves. For most attorneys, that kind of arduous effort ended the day they graduated law school. Now, we have a lawyer with us today. Trevor is here from Wisconsin, and Trevor's a good friend of mine, and his employer's a good friend of mine. And he's here, and he's most of about lawyers. He knows. I'm speaking. We're brothers in the same thing. A lot of my friends are lawyers, and a lot of my enemies are lawyers. We have some people in the legal profession that are there for the right reasons, and some there for the absolutely wrong reasons. And the ones I kind of pick out as my friends are the ones who are there for the right reasons, to try to do justice, to bring law back to the people. The ones who are there to just make a living and belong to country clubs and do all those kind of things, I have very little time for those kind of people. Now, people I know who make a lot of money, like Larry Beecraft and Bernhoff and Dick Stein, and all these people, they're just very good lawyers. They make a lot of money. They deserve every dime that they make because they work their butts off. If you go there, you're their client, they will work 300 or 400 hours just on your case. They don't have a life until your case has been resolved. So those people I give a lot of credit. They're dedicated to do justice. And there's a handful, maybe 10 in this country I can name. And that's all. That's terrible. That's only 10 lawyers in this country that have the guts, the morals, guts to go out and fight for something that they know is right. Most of them are just happy to get their money every month. They belong to the country club. They enjoy it, the prestige of being a lawyer. They don't give a damn about you or justice. There's only maybe a handful that do. That's why it's incumbent upon you to be your own lawyer. Start becoming proficient so you're better than most lawyers. And you will be very quickly. Most lawyers who are out there are really incompetent because they don't continue to learn. They finish law school, they think that's over with, and they don't even open another law book, or they don't even subscribe to a law review. They're just there, and they're doing their work, they're making money, they're happy. That's the majority of lawyers that are out there practicing. And those kind of people, they'll survive. But that's what's making the system so terribly bad, and why we're losing our freedoms. May I read off that? The second significant problem with case law is that while many judges are willing to follow it blindly, other judges seem unwilling to follow the precedent of their state Supreme Courts or the decisions of the U.S. Supreme Court, even when the issue before the court is well settled by the higher courts. While the motives of such judges may be speculated upon by layperson and lawyer alike, the solution is cheered on by the public and dreaded by the bar associations. Judges who disregard case law that is clearly and correctly applicable to the matter before them should be removed from the bench by panel of citizens. Their pensions should be forfeited upon removal, and judgment should be issued against them for any injury done to their victims. Language of law. One of the greatest stumbling blocks for the American public is understanding the laws that they represent in this act is that laws use words in a different manner than we do in common speech. There are two kinds of language that are primarily used in law. One is words, just as we use in common speech, and the other is terms, which can be substantially different than we use in common speech. Words are just that, words that are presumed to be used in their ordinary manner, and they are subject to the plain meaning rule when interpreting a statute. Their meaning must be sought out through the common English dictionaries of the era in which the statute was written. In the absence of any clear contrary intent by the legislature, the meaning found in these dictionaries is the sole meaning that must be given to the word. Terms are another matter. Terms appear no different to the layperson than words. The difference is that terms are not subject to the plain meaning rule, because the legislature has provided its own definition for the term being used. When the legislature has provided its own definition, the ordinary English dictionary must be thrown out the window. The definition given to the term by the legislature controls the meaning of it completely. Seeking out the definitions section applicable to the text that you are reading can identify the meanings of terms. Unfortunately, this may not always be as straightforward as a proposition as one might imagine. Most codes provide a section that gives definitions that are generally applicable throughout the entire code. However, any of the definitions given for the entire code are subject to be redefined in any given subtitle, chapter, section, subsection, or clause. At any time a term is redefined for a specific subtitle, chapter, section, or subsection, or clause, that redefinition of that term takes precedent within that subtitle, chapter, section, subsection, or clause over the general application definition provided for the entire code. Of course, to make matters more confusing, at any time a term is redefined for use in a subtitle, chapter, subsection, or clause, it can be redefined again and again as you move from subtitle to chapter, chapter to chapter, chapter to section, section to section, section to clause. In other words, you always have to be on your toes and make sure you know the definitions that apply to the exact text you're reading. Here's an example. 26 U.S.C. Section 7701 contains definitions that are applicable for the entire Internal Revenue Code. Section 7701A20 defines employee. For purpose of applying the provisions of Section 79 with respect to group term life insurance purchased for employees for the purpose of applying the provisions of Section 104, 105, 106 with respect to accident and health insurance or accident and health plans, and for the purpose of applying the provisions of Subtitle A with respect to contributions to or under a stock bonus, pension, profit sharing, or annuity plan with respect to distributions under such a plan, or by a trust performing such a plan, or for purposes of applying Section 125 with respect to cafeteria plans, the term employee shall include a full-time life insurance salesman who is considered an employee for the purpose of Chapter 21, or in the case of services performed before January 1st, 1951, who would be considered an employee if his services were performed during 1951. The term is redefined for the use in Chapter 24 of the Code at 26 U.S.C. 3401C. For the purpose of this chapter, the term employee includes an officer, employee, or elected official of the United States, a state, or any political subdivision thereof, or the District of Columbia, or any agency or instrumentality of any one or more of the foregoing. The term employee also includes an officer of the corporation. As you can see, the terms are defined very differently. The title-wide definition addresses insurance salesmen, while the definition in Chapter 24 addresses only government workers under a direct or indirect authority of the federal government. The corporation that is mentioned is a corporation wholly owned by the federal government. Words of art. Although words of art are often placed by the layperson in the same category as terms, they are not the same thing. Words of art are words or phrases that are particular to specific technologies, sciences, arts, professions, etc., and generally do not have the same meaning or of any meaning at all outside their own field. One example of this is the word medical orthopod. The word orthopod is generally used within the medical community to indicate a person who has surgical training, experience in arthroscopy. Outside the medical field, orthopod has no meaning whatsoever. While terms are often used by politicians and lawyers to mask the true intentions or application of a legislation for the general public, especially in tax law, words of art are proper and necessary parts of effective communication in the legal arena. Does the law work? At this juncture, we would like to warn the uninitiated student that politicians, lawyers, government employees, and officers and judges do not really care what the law says. Read that sentence again and then burn it into your memory. It will save you a lot of angry days and sleepless nights.